Witness stand.
Judge.
He was like, ha, no, you're fine. I'm like, thanks.
I see.
So when I came in, okay, perfect. Thank you.
All rise for the honorable jury. West County Superior Court is now in session. Honorable Peter H. Boystein presiding.
Morning.
Please be seated. Thank you.
Clerk Kovalenko, would you swear in the jurors, please?
Yes, Your Honor. Ladies and gentlemen of the jury, please stand for your oath. Mr. Woodburn, if you could stand and remain standing and face the jury. Ladies and gentlemen of the jury, you will each raise your right hand and keep them raised during the oath. And at the conclusion of the oath, you will each say, I do. Do you solemnly swear or affirm that you will carefully consider the evidence and the law presented to you in this case, and that you will deliver a fair and true verdict as to the charge or charges against the defendant, so help you God? Thank you. The jury may be seated. I'm going to read the charges now. This is docket number 214, 2019 CR7, charge ID 1580453C, alleging that Jeffrey Woodburn at Jefferson, New Hampshire, on or about December 15th of 2017, in the above county and state, did commit the offense of domestic violence, contrary to RSA 631-2B1B and the laws of New Hampshire, for which the defendant should be held to answer, and that the defendant did recklessly cause bodily injury to another, the adult female victim, DOB 10/12/1982, an intimate partner as defined in RSA 631-B23B, by use of physical force, to wit, biting the victim on her left hand, resulting in bruising, against the peace and dignity of the state. The next charge ID is number 1580454C, alleging that Jeffrey Woodburn at Jefferson, New Hampshire, on or about December 15th of 2017, in the above county and state, did commit the offense of simple assault, contrary to RSA 631-2A1A and the laws of New Hampshire, for which the defendant should be held to answer, and that the defendant did recklessly cause bodily injury to another, the adult female victim, DOB 10/12/1982, by biting the victim on her left hand, resulting in bruising, against the peace and dignity of the state. Ladies and gentlemen of the jury, the defendant has been arraigned on these charges and has pleaded not guilty. And for this, he puts himself upon his country for trial, which country you are. The Attorney General's office for the state has joined the issue. We are to say by your verdict if the defendant is guilty of the crimes whereof he stands charged or not guilty. Hearken to the evidence. Mr. Woodburn, you may be seated.
And the state may make its opening.
Your Honor, if we could shift if they're going to use some visuals, please.
You may.
Thanks. During a simple disagreement on the evening,
During a simple disagreement with his then fiancee, Emily Jacobs, on the evening of December 15, 2017, the defendant, Jeffrey Woodburn, got angry. And when the defendant, who had been drinking that evening, got angry, he lashed out. Instead of resolving the disagreement with his words, instead of simply walking away, the defendant opted for violence and sank his teeth into Emily's left hand, bit down, and did not let go. And he bit down so hard that it left Emily that it left Emily in pain, bruised and in pain for days afterwards. The defendant, a grown man, hit Emily because he had to have things his way and only his way. So let's talk about what led up to the 6'2", 220-pound defendant biting the hand of his much smaller fiancée back on that evening in 2017. Emily and the defendant met back in 2012 when the defendant was running for state senate. And he and Emily eventually became friends through their shared interest in politics. Now, that friendship became a romantic relationship in 2017, and the two became engaged in 2017. During the time of their relationship, Emily and the defendant during the time of their relationship, Emily lived at 144 Highfield Lane here in Jefferson, New Hampshire, right off of Route 2, while the defendant lived in Whitefield. Now, because the two were engaged at the time, the defendant would often stay over at Emily's house at Highfield Lane. And you'll hear that Emily wasn't the only person that the defendant knew on Highfield Lane at that time. Through local politics, the defendant had become friendly with the residents of 37 and 99 Highfield Lane as well. On the evening of December 15, 2017, Emily and the defendant attended a Christmas party in Lancaster, New Hampshire. But because the defendant wanted to drink at that party, he got dropped off by a friend. And because the defendant wanted to drink at that party, it was up to Emily to drive her own car separately and then to drive the couple back to her home afterwards. So at the party, the defendant got his way and he got to drink. And afterwards, he and Emily got in Emily's car and left for the evening. The two then set out for 144 Highfield Lane for the remainder of the evening. Now, during the drive, Emily expressed her frustration with the defendant for not having driven his own car to the party. It meant that Emily would now need to get up early the next morning, leave her two young children at home, and drive the defendant all the way to his home in Whitefield. All because the defendant wanted to drink at the party, and all because the defendant wanted to be home early the next morning. Well, the defendant did not like Emily questioning him one bit. It made him very upset, and he couldn't let it go. And he became angry. He began raising his voice and arguing with Emily and repeating similar questions to her over and over and over again. And when Emily eventually stopped responding to those questions, the defendant became even more angry. So when they eventually reached the familiar confines of Highfield Lane in Jefferson, New Hampshire, the defendant told Emily that he wanted to get out. So shortly after passing the red house located at 76 Highfield Lane, Emily pulled over the car as the defendant wished. But as the defendant began getting out of the car, he threatened Emily that he was going to call Art, referring to the couple's mutual friend, Arthur McGrath. Now, you'll hear that during this period of time, the defendant had told Emily that she was no longer allowed to speak to Art, and this was because the defendant believed that Art had feelings for Emily. So when the defendant threatened to call Art during this incident on December 15, 2017, Emily thought it was ridiculous. It was ridiculous that the defendant apparently had a different rule for himself and could call Art when it was convenient for him, but she wasn't allowed to. So because it was ridiculous, Emily reached for the defendant's phone, which was in his hand at the time, to stop him from calling Art. And that's all Emily did. She did not touch the defendant. She did not hit the defendant. She did not slap the defendant. She did not threaten the defendant, either verbally or physically. And she did not lock the doors of the car or try to stop him from getting out. She simply reached for the defendant's phone to stop him from calling Art and to stop the situation from further escalating. The evidence will show, however, that was was all it took for the defendant, in his anger, to lash out. As Emily reached for the phone, the defendant bit her on the left hand and did not let go. He bit so hard that Emily was in pain for days afterwards, so much so that she even had a difficult time picking up a pen at work. The defendant also bit Emily so hard that it left bruises on Emily's hand that were still there 4 days later, as you can see in these photographs here. Now, after he bit her, the defendant got out and got his way once again. He got to call her. And it was only after Emily got out and apologized to the defendant that he got back into the car and they continued up the remainder of Highfield Lane to Emily's house. Now, as the clerk, for biting and injuring Emily in this case, the defendant is charged with 2 offenses, as the clerk just read to you. One charges him with recklessly causing bodily injury to Emily by biting her, resulting in bruising, and the second charges him with domestic violence for committing that same act on Emily, who was his intimate partner at the time. After you've heard the evidence in this case, there will be no question that the defendant committed these offenses and did so with zero justification beyond a reasonable doubt. And as a result, at the end of this trial, we will ask you to hold the defendant accountable and find him guilty.
And defense counsel may make your opening.
Thank you, Your Honor. Morning. Yeah, once again, I just want to introduce myself. I'm Mark Sisti. You know that's Jeff. He's the guy on trial. And, it's kind of interesting. In many, many ways, there aren't going to be a lot of conflicting facts here. And quite frankly, it's not all that complicated. Just a few minutes ago, in essence, what you heard was that the prosecutor told you that Emily initiated the contact on the road that resulted in that scramble for the phone. But let me kind of back up a little bit and let's go through this for a second, okay? Because we discussed this last week, and I don't want you to forget it. Self-defense is an absolute defense. A man or a woman cannot have unprivileged contact with another individual, all right? Period. And if they do, the person that has been contacted has the absolute right to defend himself or herself. Absolutely. And for the prosecution to prove their case, they have to prove beyond a reasonable doubt, that in this case, Jeff's actions were not self-defense. Okay, so let's take a look at the facts. And let's do it rationally. And in this case, I'm going to ask you to use your common sense. Because common sense is going to direct you to a clear verdict of not guilty at the end of this case. We know in this culture, and you saw it in your film before you were sworn in as jurors last week, that the state, the prosecution, has the burden of proof beyond a reasonable doubt. Not just a little bit, not just that somebody's probably guilty, but beyond a reasonable doubt. And we all agreed last week that that's the right standard, okay? We all know that, because if you're sitting over there where Jeff is, that's the standard you would want to be judged, correct? So if we utilize the tools of proof beyond a reasonable doubt, the principle of presumption of innocence, and the defense of self-defense, you will be steered to one inevitable verdict. You saw on the screen some images. When you get to the deliberation room, you'll get to have images, okay, that were shown on the screen, okay? Now let me make this very, very clear. That is her left hand. That's Emily Jacobs' left hand. Okay. Left hand. The driver of an automobile's left hand. Okay. Why did that left hand have a bruise on it after the 15th of December, 2017? Why? Well, the prosecutor told you why, and it was open. The prosecutor told you that without the right or the privilege or the consent of Jeffrey Woodburn, that she, on her own, because she wanted to control the situation, grabbed for Jeff's phone. And you know what? She's going to admit that. That's not going to be hard during the course of this trial for me to get her to answer that question. She had no right and no reason to grab for that phone. And she had no right or no reason to try to stop Jeff Woodburn from leaving that car. And that's what she wanted to do. That's what she wanted to do. Things don't happen in a vacuum, all right? You'll get to understand a little bit about this road. This isn't a main highway in the middle of Lancaster. This is a rural road on a cold December night, unlit. Jeff Woodburn wanted to de-escalate the situation in that car. He wanted to get out of the car. She wanted to restrain him. That's what this is all about. That's what this is all about. This isn't some gratuitous act of violence on the part of Jeff Woodburn. Jeff Woodburn wanted nothing to do with biting the left hand of Emily Jacobs on December 15th, 2017. You know what he wanted to do? He wanted to get out of the car. You know what she wanted to do? She wanted to keep him from doing it. And what did that result in? A struggle for the phone. A struggle for his phone. A struggle for a phone that he wanted to use to call his friend. To call his friend so that he could be picked up in the middle of the night on a rural road in Jefferson, New Hampshire. That's what this case is about. That's what this case is about. It's not fueled by, crazy anger. It's not fueled by crazy amounts of alcohol. It's fueled by one person trying to keep another person from exercising his freedom to leave a car and make a phone call with his phone without it being grabbed from his hand in the middle of the night. That's what this case is about. I want to keep it clear. I want you to use the lens of the legal principles that you've all been told, not only on the tape, but by the judge. And at the end of this case, you're going to hear it again. Because the reason that we sit as jurors in this country is to keep those principles alive and to keep them solid, not to weaken them. But don't get caught up in the drama in this case. The facts of this case and the reason for the fight, which by the way did take place, to free the phone from the grasp of Emily Jacobs. The facts of this case don't rise and fall on Jeff Woodburn being 6'2". Okay? Has nothing to do with it. Jeff Woodburn could be 7'8", and Emily Jacobs could be 4'2". She has no right, no reason to grab that hand of Jeff's or the phone of Jeff's. None. So what I'm going to ask you to do is keep a clear head, stay with the law, follow the facts. And I'm telling you, okay, that when I first got up here, I started speaking to you shortly before 9:30 this morning, that what I told you was going to come true by the end of this case. Emily Jacobs initiated the contact by trying to keep Jeff Woodburn in her car on a cold December night in an unlit area when he wanted to get out with his property to make a phone call to get away from the situation. And you know what's interesting? And you heard it in the state's opening. Is that I'll bet you're going to see, with your common sense, that Emily Jacobs knew she was wrong. When she asked him to get back in the car. When she continued driving down the road with 6'2", angry Jeff Woodburn to her home. And where I tell you, they slept together that night in her room. That's what the facts of the case are going to tell you. And there'll be a little bit more. Something that was left out in the prosecutor's opening was that, in fact, a little bit earlier, a little bit prior to that stop on the road where Emily lived, there was a stop in front of the Cabot Inn. I don't know where y'all, maybe you know, maybe you don't know. The Cabot Inn right outside of Lancaster, right across from there, pretty much. And Jeff tried to get out there too. And you know what? He did get out there. He actually made a phone call. And then she convinced him to get back in the car. She convinced him to get back. And he got back in the car. And then they went up the road. I want you to use your common sense. You know, the one thing you folks didn't abandon when you walked into this courthouse is the most precious thing that's going to guide this case. So why don't you use that, use the law, and the facts are going to come to you. There's nothing complicated about this. Okay? It's just a matter of being able to line those facts up and match them up with the law at the end of the case. Okay? No emotion, no drama. Let's get through this. And thank you again for serving on this jury. Thank you. Thank you, Your Honor.
State may call its first witness.
Thank you, Your Honor. Let me have a moment just to take 2 minutes. The state calls Emily Jacobs. swear the witness?
You may.
Ms. Jacobs, please raise your right hand. Do you swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth under the pain and penalty of perjury?
Yes, I do.
Thank you. Please have a seat. Good morning.
Good morning.
Ms. Jacobs, could you please tell us your first and last name and spell your last name for the record?
Sure. Emily Jacobs, EMILYJACOBS,
Ms. Jacobs, where do you live currently?
in Maine.
Before you lived in Maine, did you live in New Hampshire?
Yes, I did.
Where in New Hampshire?
I lived in Jefferson, New Hampshire.
Did you grow up in New Hampshire?
Yes,
What town?
in Whitefield.
Do you have any children?
Yes, I do.
Could you tell us how many and how old they are?
Yes, I have 2 boys, and one is 14 and the other one is 16.
Ms. Jacobs, did you attend college?
Yes, I did.
What college?
I went to the University of New Hampshire in Durham.
In addition to your time at the University of New Hampshire, do you have any advanced degrees?
Yes, I do.
Where are those from?
Southern New Hampshire University in Manchester, and then I went to University of Albany in New York.
Ms. Jacobs, what do you do for work?
Yes, I'm a clinician.
Thank you. Ms. Jacobs, do you know a man named Jeffrey Woodburn?
Yes, I do.
From 2015 to 2018, were you in a romantic, intimate relationship with Jeffrey Woodburn?
Yes, I was.
Do you see Mr. Woodburn here in the courtroom today?
Yes.
Could you please identify him by pointing at him and identifying verbally a piece of clothing he's wearing?
He's over there. He has glasses on and like a brown shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
That's so stipulated.
Thank you.
It will.
Ms. Jacobs, I'd like to ask you now about how your relationship with Mr. Woodburn began. When did you first meet him?
I first met Jeff in 2012 at his house. I had gone to his house because he was running for Senate that year, and I was looking for a job because I had just come back from New York. And I had a community economic development degree and was just looking for a way that I could help the community.
You mentioned that Mr. Woodburn was running for Senate at the time. Was that state Senate?
Yes.
Did you begin a romantic relationship with him at that point in 2012?
No.
Did you nevertheless maintain some sort of relationship with him?
Yes, we had a friendship.
And over the next few years, did you continue to be friends with Mr. Woodburn?
Yes, I did.
And did you have any sort of interactions with him? What sort of things would you interact about?
Yes, we shared politics. We were both very involved in the New Hampshire Democratic Party, and eventually I became chair of the Coos County Democratic Party, and I helped to elect candidates, and one of the candidates was Jeff, and I worked hard to get him elected.
Ms. Jacobs, when did you begin a romantic relationship with Mr. Woodburn?
Yes, it was roughly summer of 2017, and then we became intimate in October.
Okay. At some point, did you become engaged with the defendant?
Yes, I did.
When was that?
On November 21st, 2017.
Okay. And just to back up, did you begin a romantic relationship with the defendant in 2017?
No, I'm sorry. I became, that was 2015. Thank you.
So is it fair to say you began dating in 2015?
Yes,
You became engaged in 2017?
yes, correct.
About when in 2017 was that?
2017, November 21st was when we became engaged.
And at some point, did your romantic relationship with the defendant end?
Yes, it did.
Roughly when was that?
That was in summer of 2018.
Ms. Jacobs, during the time that you were romantically involved with the defendant, when you were dating and then when you were engaged, did you live together or did you have separate homes?
We always had separate homes.
Would the defendant sometimes spend the night at your home?
Yes, he would.
But how often would he do that?
A couple days a week.
Did he keep any personal items there?
Yes, he did.
And where was your home at that time?
I was living on Highfield Lane in Jefferson, New Hampshire.
doing that. Ms. Jacobs, I'm showing you Exhibit 3. Can you take a look at that?
Yes.
And do you see your home there?
Yes, I do.
And what was the address again?
144 Highfield Lane.
Is that in Jefferson?
It's in Jefferson.
During that time, where did the defendant live? What town?
We lived in Whitefield.
How far away was Whitefield from your home?
It was roughly 15 minutes.
See if we can get this map on the screen. Not too much about that. Did it, all right. So, is your home here, 144 Highfield Lane?
Yes, that's my home.
And I'm going to trace with my pen here, just so the jurors can see. Is that Highfield Lane
Yes,
that I'm
it is.
tracing here?
Mhm.
And what would this road be here? This.
That was Route 2.
Okay. What kind of road is Highfield Lane?
It's a dirt road with maybe 10 homes on it.
Ms. Jacobs, when you lived on Highfield Lane in Jefferson, did you get to know any of your neighbors who lived in those other homes?
Yes.
Okay. Did you get to know people who lived at 99 Highfield Lane?
Oh, Don and Mark Bechtel.
Okay. So, who are Don and Mark Bechtel?
The family friends of ours that I've known since my children were very young. My mom and Don were teachers together at the Wakefield Elementary School.
And so did they live at 99 Highfield Lane?
Yes, he did.
While you were dating and then engaged with the defendant, did he get to know the people who lived at 99 Highfield Lane?
Yes, he knew both Mark and Don.
Briefly, could you tell us, how did he know them?
Yes, so his children were also in the Wakefield School, and Don was an art teacher and had the kids in class. At least I remember Dylan was in that Don's class. Also, Jeff had been to Don's house before we had started dating, so he had known where she lived. And also, Mark Bechtel played guitar at the Woodburn house when they had a restaurant open, so they were friends from then.
Thank you. Ms. Jacobs, you'll see 37 Highfield Lane on that map as well. Did you know the people who lived at 37 Highfield Lane while you lived there?
Yes, Corey and Roger Hughes.
And did the defendant know Corey and Roger Hughes as well during that time that you were engaged?
Yes, he did.
Okay. How did the defendant know the people at 37 Highfield Lane?
Yes, so Corey Hughes was very active in politics, and she came to, the first time I met her was at it was a party that Jeff had when he won Senate at the Inn at Whitefield, and she was there to support him. Corey was also the secretary of the Coas County Democratic Party when I was chair.
Ms. Jacobs, I'm going to ask you now about a person whose name the jurors are going to hear later. Do you know a person named Art McGrath or Arthur McGrath?
Yes, I do.
Could you please tell the jurors who Art McGrath is?
So Art was a friend of Jeff's. They went to high school together, and they were really close, and yeah.
So did you meet Mr. McGrath through the defendant?
Yes, I did.
After meeting Mr. McGrath, did you become friends with him?
Yes.
What sort of things would you and Mr. McGrath do together?
Talking politics. He's just really involved in the outside, going on hikes, just involving our kids, ended up meeting as well, and they became really close friends.
Did the defendant take part in any of those activities you would do with Art McGrath and his kids and your children?
Yeah, so sometimes Jeff would be there, and sometimes it was just Art and the kids and me.
Does Mr. McGrath remain your friend today?
Yes.
At any point during your romantic relationship with the defendant, did there come a time when the defendant told you that you were not allowed to speak to Art McGrath?
Yes.
Why did he do that?
I'm going to object.
Approach. Yes, Attorney Assistant.
Yeah, I don't think she can opine on what his intent or what his opinion was. I mean, she can only speculate.
I can ask her, why did he tell her you're not allowed to speak with her?
You already said that. That's in the record. That you're not
I'll
allowed to
sustain
speak
the
with her.
objection, at least to the form of that question. You can ask another one.
Thank you.
We got a trap over here.
Ms. Jacobs, did the defendant tell you why you were not allowed to speak to Mr. McGrath?
Yes, he did.
What did he say?
He said because I had Jeff, that Art was interested in a relationship with me, and that was in summer 2017, that he did not want me to talk with Art anymore.
Did you obey that directive?
Yes, I did.
Ms. Jacobs, did you ever have a romantic relationship with Art McGrath?
No, I did not.
Ms. Jacobs, I'd like to ask you now about the evening of December 15th of 2017. What were you doing that evening?
So on the 15th of December 2017, I went to a Christmas party at Sally's house, and then Jeff came. He got dropped off later.
So you mentioned Sally's house. Was that a friend of yours?
Yes,
And where was her house? What town?
she was in Lancaster.
Okay. So there's a Christmas party on December 15th of 2017. You attended that party?
Yes, I did.
The defendant also attended?
Yes, he did.
Okay. Did you arrive together or separately?
He took his own car. I'm sorry, he was dropped off. I took my own car.
Had you and the defendant discussed a plan for that evening and how you would leave the party?
Yes.
What was the plan that you had discussed with the defendant?
Yes, Jeff wanted to drink, and so the plan was he wanted me to drive him back to my house on Highfield Lane in Jefferson after the party.
Did that plan include plans for the next morning as well?
Yes, it did.
And what was the plan for the next morning?
So the next morning, Jeff wanted us to wake up early so that he could get early start to the day. He wanted to go first to the gym and then to the dump. And so my job was to bring him back to his house in Wakefield.
Was there alcohol at that party on December 15th?
Yes.
Did you drink?
No.
Did the defendant drink?
Yes, he did.
What happened when you left the party?
When we left the party, we got in the car. I was driving. It was quiet at first, and then I said to Jeff, I said, I don't understand why you want to drink tonight. Why you wanted me to bring you back the next day. Why you couldn't have brought your own car.
Were you happy about the plan to drive him home early the next morning?
It just felt so unfair.
And why did it feel unfair?
Because I had to leave my kids. I had to get up early, and I had to go to his house, and I couldn't do what I wanted to do in that Saturday morning.
So, when you told the defendant how you felt about that, was that while you were driving home to Jefferson?
Mm-hmm.
What was his reaction?
He was really upset.
What did he say?
He was upset with the fact that I questioned him, and he wouldn't let it go.
When you say he wouldn't let it go, what do you mean?
He just kept talking about it. He didn't like the fact that I had questioned him, and he became angry over it, and he then started questioning me, and he asked me, he's like, why did you bring it up? Why would you bring it up? And he didn't like the fact that I had brought up the fact that it was bothering me that I had to bring him back the next day early, and why he had to drink. I was questioning his decision, and it was the same thing over and over, and I wasn't responding. I wasn't answering him. And then he said he wanted me to pull the car over, and so I immediately pulled the car over.
Thank you, Ms. Jacobs. If you need a minute, please let us know.
Okay.
So, when he was... Give me a second. When the defendant was expressing those things to you, what was his tone of voice?
He was yelling.
What was his body language like?
I didn't see his body. I was driving.
So you were in the driver's seat?
Yeah.
The car was moving?
Mm-hmm.
The defendant was in the passenger seat?
Yes, he was.
Was there anyone else in the car?
No, there wasn't.
You mentioned that the defendant at some point asked you to pull over the car.
Yes.
When he asked you to pull over the car, where were you?
We were right by my neighbor's red house on Highfield Lane in Jefferson, just above the red house, and number 76.
Okay. And Ms. Jacobs, you see that number 76 on the map there?
I think so. It's right in the middle there.
Okay. So when the defendant asked you to pull over the car, did you obey that?
Yes, I did, right away.
What happened next?
As he was getting out of the car, he had already opened the door, and he said, I'm going to call Art and ask Art for a ride. And I thought that was so ridiculous because he wouldn't even let me talk to Art.
Ms. Jacobs, is Art McGrath?
Art McGrath.
The person we spoke of earlier?
Mm-hmm.
When he made that statement, the defendant said he was going to call Art. Was he in the car?
No, he was on his way out. The door was open.
Who opened the door?
He opened the door.
So was the door locked?
The door was never locked.
When he said that he was going to call Art, what did you do?
Then that's when I reached for his phone.
What hand did you use to reach for his phone?
My left hand.
So you're saying the driver's seat, did you reach across your body?
Yes. I had my seatbelt on.
Where was the defendant's phone at that time?
It was in his hand.
Did he have it up by his ear like he was making a phone call?
No.
Where was it?
It was down, a little bit further down.
What happened when you reached for that phone?
That's when he bit me.
So, you said the defendant bit you?
He bit my hand.
Could you lift your hand up, please? And for the record, are you raising your left hand?
Just my left hand.
Could you please show the jury where the defendant bit you? Okay, so you're referring to an area around your thumb. When the defendant bit you, how long was your hand in his mouth?
it felt like forever. My hand was in his teeth.
How did it feel when he bit you?
It hurt a lot. I just wanted him to let go, and I couldn't withdraw my hand.
Eventually, did he let go?
Yes.
Either before he bit you, during the bite, or after he bit you? Had you made any physical contact with the defendant?
No.
Did you touch him in any way?
No.
Did you punch him?
No.
Did you slap him?
No.
Did you raise your arm and threaten to hit him?
No.
Did you try to hit him?
No.
After he let go of you and took his hand off of his mouth off of your hand, what did the defendant do?
He got out of the car and he made a call. I think it was Art McGrath. I unbuckled my seatbelt and I opened the door and I got out and I went over to Jeff and I said, "Can we just go home, please?" And then I said I was sorry.
Ms. Jacobs, so after he bit you, he got out of the car and made a phone call?
Yes.
And then you got out of the car and spoke to him as well?
Yes.
If the defendant had just bitten you, why did you tell him that you were sorry?
I felt it was my fault. He made me feel like I was to blame because I brought it up. I mentioned to him that I didn't understand why he needed to drink. I didn't understand why we had to leave early the next morning to do what he wanted to do, to bring him back to his house so he could get what he wanted to get done. And I felt like I was to blame for that.
Ms. Jacobs, after you apologized to the defendant, did he get back in the car?
Yes, he did. Yes.
And did you get back in the car as well?
Yes, we did.
And where did you two go?
We went home.
Okay. And did you spend the night at your house?
Yes.
After this incident, did the defendant ever apologize to you?
No.
Ms. Jacobs, at any point while you were in the car with the defendant on Highfield Lane, did you tell him not to get out of the car?
No.
Did you tell him, or did you do anything to prevent him from leaving the car?
No.
Did you lock the door to keep him from getting out of the car?
No.
Ms. Jacobs, did you report this incident to the police after it happened?
No, I did not.
Why not?
I love him. I didn't think about it.
Ms. Jacobs, you mentioned that you pulled the car over somewhere in the area of a red house near 76 Highfield Lane.
Yes.
Is that the only time you pulled the car over to the side of the road on December 15th of 2017?
Yes.
And at any point did you refuse to pull the car over when the defendant asked you?
No.
Ms. Jacobs, I'm showing you Exhibit 1 on the screen. Can you see it? Is that your left hand?
Yes.
And did you take that photo?
Yes.
When did you take it?
I think it was the Tuesday after that happened. I want to say it was the 19th of December.
And does that photo show bruising on your left hand?
Yes, it does.
I'm showing you Exhibit 2 now. Is this another photo of your hand?
Yes.
Did you also take that photo?
I did.
Does that photo show bruising on your hand?
Yes, it does.
So bruising on your hand in these two photos. Is that bruising a result of the defendant biting you on the left hand?
Yes.
Is that the same bite that we're talking about on
Yes.
December 15th?
Mm-hmm.
After the defendant bit you, how did your hand feel?
It hurt. It ached. I had trouble moving it at first. I tried to, I remember being at work and I tried to reach for a pen. I'm right-handed, but at work my pen container was on my left side of my desk next to the computer monitor, and I remember trying to reach for it and it ached. I thought I could grab the pen and I just struggled with that.
Thank you, Ms. Jacobs. One moment, please, Your Honor. Thank you, Ms. Jacobs. I have no further questions for you right now.
Defense counsel may inquire.
Thank you, Your Honor. Cheers. Give me some. If we can have a second, Judge, we're going to get some water for the
Thank you, sir.
How's that?
Thank you.
Ms. Jacobs, we haven't met, have we?
No.
Okay. I'm not going to be real long with you on the stand because I think you're going to agree with most everything I ask you. Okay?
I don't know.
Well, let's find out together, okay? On the 15th of December 2017, prior to getting in your car to meet with Jeff, you had already discussed the plans with Jeff, right?
Mm-hmm.
All right, so let's do this so we all understand. It wouldn't have come as a surprise to you that Jeff wanted you to drive that night, right?
Correct.
That's absolutely true that you clearly knew before the evening started that Jeff wanted you to drive.
Yes.
And before you got in your car and you left your home, you knew that Jeff wanted you to drive to the party so that he could drink, right?
Mm-hmm.
That didn't come as a surprise to you, right?
No, I did not.
Before you placed your keys in the ignition of your automobile and on your own went to that party to meet Jeff,
Mm-hmm.
you knew, one, that he wanted you to drive that night, right?
Yes.
Two, that he was going to be drinking, right?
Yes.
Did you argue with him on the phone about that
On the phone?
before you left your home that day?
I don't remember that.
Did you tell him, I don't want to drive, Jeff? Did you say anything like that?
I don't remember that.
Did you say, come on, Jeff, I don't want to go to a party and have you drink? Anything like that?
I don't remember that.
No. And the plans that night were that you would drive so he could drink, and that you would then drive Jeff back to your home, right?
Yes.
Did you tell him before he started your car to go out that night to meet up with him that you didn't want him coming back to your home that night?
Do you mean before? I'm sorry. Do you mean because I didn't meet up with him? I was at the party.
I understand you were at the party. You were there to meet with Jeff, right?
I was meet with a lot of people. Yeah.
I understand that. But you knew that you would be driving that night, right?
Yes, correct.
Yeah. Okay. And you knew you'd be driving home that night, right?
Yes, that's correct.
Did you tell him you didn't want him coming home with you that night?
No, that was not said.
No, because the plan was you were going to drive, he was going to drink, you were going to be at the party together, and then you were going to drive him home, right?
Yes,
You didn't argue about that before.
I did not.
You didn't question what was going on before, right?
I did not.
Not at all, right?
We didn't have time to talk about it.
You didn't even have to go to the party, did you?
Me?
Yeah, you.
I wanted to go to Sally's party.
You did, and you wanted to meet with Jeff.
No, I wasn't there to meet with Jeff. I was there to go to the party.
You were just there to go to the party,
Yes.
and you knew he was going to be there.
Sally and I have been friends for a long time.
That's good. I'm glad that you and Sally are friends. You were engaged to this guy, though, right? Correct?
Yes.
Okay. Now, that's not a hard question, all right? Nothing hard about that question. You wanted to meet with Jeff, right?
Wanted to go to the party, Mr. Sisti.
I'm glad you wanted to go to the party, and you knew that guy, the 6'2" Jeff Woodburn, would be there, right? Right?
Yes. But he
Okay.
he said he was going to come.
Yeah.
Yeah.
And he was going to go home with you,
Yes.
and you were going to be the driver.
Yes.
Okay. And in fact, everybody met there, and at the end of the party, just as planned, he got in your car, right?
Yes, he did. Mm-hmm.
And when he got in the car and you started driving, nothing was going on, right?
It was quiet at first, yeah.
Yeah. And then you told the jury, when the prosecutor was questioning you, that things were calm, right?
Mm-hmm.
And then you started questioning Jeff about why he had to drink, right?
I'm sorry I did. Yeah.
Well, you don't have to be sorry. The reality is that what you did. That's what you did, right? Correct? I mean, he didn't start out angry or arguing with you, did he?
No.
No. He got in the car after the party, after he drank, just like you guys planned, to go to your home, right?
This is true.
That is absolutely true. And as that plan was taking the course that everybody expected, you started questioning him as to why he was drinking, right?
I did.
Okay.
It didn't seem fair, Mr. Sisti.
Well, you didn't tell him that beforehand, did you?
No.
No. So you started that confrontation, correct?
I brought it to his attention, yes.
Out of nowhere, right?
Mm-hmm.
That's how the drive started back to your home, correct?
Yes.
Okay. He didn't get in the car angry, did he?
No, we weren't talking for the first part of it.
All right. So now you're driving towards your home. Now I understand from your testimony that you're not going to agree that you pulled over prior to getting to your road.
I only pulled over on Highfield Lane.
I know that's what your testimony is.
Mm-hmm.
You're not going to agree that, in fact, you pulled over almost across from the Cabot Inn on Route 2 on the way to Jefferson.
We never pulled over on Route 2.
That's what you're saying.
It didn't happen.
Okay. And you're also saying that Jeff didn't get out of the car there, right?
We didn't pull over there.
Okay. And you're also saying you didn't make a phone call there, right?
He made a phone call on Highfield Lane.
We'll get to that. But I just want to stay where we are on Route 2, okay?
Right.
My question, okay? You're saying that you never pulled over in front of the Cabot Inn, he never got out, and he never made a phone call.
I don't know where the Cabot Inn is.
You lived around here for a long time. You went right by it. It's on Route 2.
I'm sorry, I don't remember.
You don't know where the Cabot Inn is? Is that what you're telling us? Well,
I'm sorry, I don't remember.
I'm going to ask you this simple question. Do you know where the Cabot Inn is? You know what I'm talking about?
Been asked and answered 3 times, sustained.
How long have you lived in this area?
I lived in Whitefield for most of my life. I went to White Mountains Regional High School, and I lived in Jefferson for about 5 years.
Do you drive back and forth on Route 2 from Jefferson to Lancaster on occasion?
Rarely, like if I'm going to, if I had to go to Shaw's, for example, or, but I don't used to go to Market Basket a lot down in Tilton for groceries.
So it's not an unusual route for you to take, right?
That's not a usual route for me to take. No.
Okay, I just want to make sure we know that.
Okay.
When you get to your road, you make a left off of Route 2.
Get off of my road. If I was going to go left onto Route 2, I'd be going towards Gorham.
And if you're going right, you're going towards.
I'd be going towards Whitefield or Lancaster, yes.
Okay. And that night, were you traveling on Route 2?
Yes, we were.
And where were you coming from?
From Lancaster, and I can't remember her road. Dallas Road, I don't remember.
Okay, so you come up to your road and you make a left, right? Correct.
Come up to my, yes, that's correct. Yep.
About a quarter mile down your road, that's when Jeff wants out of the car, right?
We were on Highfield Lane. We're up by the Red House, which is number 776, and that's where I pulled over.
That's when the car's pulled over, right?
Right.
And this testimony about it's not locked or it's unlocked and all this stuff. I mean, Jeff can control the lock on the passenger side of your car, right?
I didn't ask the question. Yeah, I guess so.
Yeah. I mean, it's not as though he can't unlock a door on the passenger side of
I
the
guess
car.
I assume so. Yes.
Yeah. He wanted to get out, right?
He said he wanted to get out, and he got out.
Well, he didn't get out without a confrontation taking place first, correct?
I don't know what you're referring to, Mr. Sisley.
We're referring to the subject of this trial. We're referring to you grabbing for his phone.
I was reaching for his phone. Yes.
Right.
That's correct.
Without any right to reach for his phone, right?
That's true.
That's absolutely true. Right?
Mm-hmm.
I mean, you'd agree with me. There wouldn't be a bite mark on your hand if you hadn't initiated that activity for reaching for the phone, correct?
Why did he have to bite me?
Listen, he wasn't just out of nowhere biting you, was he? You were going for his phone.
I didn't know he was going to bite me.
Well, I'm not saying you didn't know he was going to bite you, but he probably didn't know you were going to grab his phone either, was he?
I didn't touch his phone, Mr.
You were
Sisley.
grabbing for his phone
I was reaching for his phone.
to take it.
Yes. Or try. There's no way I could reach it.
There was no way you could
I'll
reach
try.
it. Yeah. Well, what if we were saying that that hand was darn close to that phone? How about that?
I don't remember it being that close.
Well, you had to reach over with your left hand from the driver's side of the car all the way over to the passenger side to go for that phone, right?
It was a long reach, and I had my seatbelt on.
Okay, I'm glad you had your seatbelt on, but you're right, it was a long, intentional reach to go for his phone, right? Yes, you did. You intended on taking his property, right?
Objection. Can we approach?
You may.
There's no defensive property.
There's a
Noticed here. So I think using that phrasing is very misleading to the jury. Saying, assigning an intent to this witness that she intended to take his property.
I believe that this is the context of the contact. We believe that she actually grabbed the phone, first of all, that there was a struggle for the phone, that there was actual physical contact. Hold it. I mean, that this didn't just come up out of nowhere. She intended on taking his property. It made it clear she was trying to take his property. He was trying to keep his property, and there was a struggle for that property. And in order to keep his property, he bit her.
That's not been noticed as a defense. Defensive property is not.
Oh, I'm sorry, Judge.
It's self-defense. It's not defensive property.
Well, only objection, because again, the question is, did she intend to take his phone? His phone is his property. I agree that if Attorney Sisley sought to start arguing defensive property in closing, that would be impermissible because he isn't the defensive property.
Right. I agree with that.
These are the circumstances surrounding this altercation, so the objection is overruled.
Thank you.
Thanks.
Let me do it again. You intended to take his property.
I was reaching for his phone, yes.
Yes. You were trying to take something that was his, right?
It was his, yes.
That was in his hand, right?
Yes, it was.
So you were going to use your hand to take property from his hand, right?
I was trying to reach to get it, yes.
And that's what initiated the contact, right?
I don't understand.
That's why you got bit,
Objection.
correct?
Approach.
Just asking this witness to testify as to why the defendant bit her.
I'm going to sustain the objection before the question. I'll strike it. The objection is sustained. The question is stricken. The jury is instructed to disregard it.
Did Mr. Woodburn try to bite you before you went for his phone?
No.
Not at all, right? No. And it was only during that course of conduct, your course of conduct, that you started, that you got bit. Right?
I'm sorry.
No. It's not that I'm sorry. Okay? It's during that course of conduct that you started, that you got bit. Right? Right? Because Jeff didn't want you to take his phone away. Right?
Objection.
Sustained as to the form of the question.
Because Jeff was holding on to his phone. Right?
Yes, he was.
The phone you wanted. Right?
Yes.
The phone you wanted so you could keep him from making a phone call, right?
I didn't want him to call Art.
Yes, the phone you wanted so he couldn't make a phone call, right?
Right.
The phone you wanted and the person you wanted to keep from making the phone call, right?
Objection.
Asked and answered.
Yes.
Sustained.
You didn't want him to leave the car and make a phone call, correct?
No.
And that's what you were trying to stop.
It wasn't that. It was, said he was calling Art.
I understand that. You wanted to stop him from leaving the car to make the phone call, correct?
Objection.
Basis?
Asked and answered.
I'll overrule that one.
Thank you. You wanted him to stay in that car and not make that phone call.
It wasn't the phone call itself. It was, he said he was going to call Art. And he wouldn't let me talk to Art, so he was playing this game. And
Okay. You wanted to keep him in the car, keep him from making the phone call, correct?
I did not want to keep him in the car. I had no one, that didn't matter to me.
The phone was with him, right?
Yes.
If he left the car, he'd have the phone, wouldn't he?
Yes.
So you were trying to keep him in the car.
No.
Okay. You just wanted the phone, is that what you're saying?
I just didn't want him to call Art.
Did you ask him for the phone?
No, I didn't.
In fact, there was a struggle for the phone, right?
No.
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 He kept his phone, didn't he?
He had it in his hand.
And he left that car, didn't he?
Yes, he did.
He left the car with the phone that you were trying to take, right?
Yes.
And he did that after he bit you.
He took
Right.
the phone after he bit me. Yes, he got out of the car after he bit me, yes.
Right. And as soon as he bit you and he had his phone, he then left the car, right?
Yes, he did.
He then left the car and he went outside the car and he initiated a phone call.
He was on the phone outside the car, yes.
And instead of going home to your home that was just yards away, You got out of the car.
Yes, he did.
He didn't say, Emily, I want to get back in the car. Let's go to your house. He didn't say anything like that, did he?
I don't recall that, no.
No, in fact, it was you that got out of the car and said, why don't you get back in the car and come home with me, right?
Yeah.
After you told him. After you told him.
I felt responsible for him.
Where you get that? After you told him, right after the incident with the phone, right after the fact that you didn't want him to leave the car with that phone, you told him that you were sorry, right?
Mm-hmm.
You told him you were sorry. You told him, let's go to my house, right?
Yeah, I said, Jeff, let's just go home.
And you did, right?
Yes, he did.
And you spent the night together, right?
Yes, we did.
And you didn't report this to the police, right?
Did not.
And you didn't report this injury to any medical profession, correct?
I did not, no.
Let me ask you one other thing. You were shown photographs, you were shown images, and the jury saw them. Of your hand, right? Right?
Yes, my hand.
Yes. And your hand in this position too, right?
Yep.
Yep. Let me just show the jury again. Yeah. This is the hand that you say he bit you so hard that it caused excruciating pain?
Excruciating.
And pain and all kinds of restricted movement for days?
Yes. Well, it was hard to move.
I'm just asking, is that what you tell the jury?
Mm-hmm.
The hand that is clenched in a fist 3 days later?
Yeah, I had to move it to that position, my other hand.
The hand here that still has the engagement ring on?
Yes.
Did you show these to Jeff 3 days later?
No.
Did you secretly take these and kind of keep them from Jeff?
Objection.
Approach.
Participation. Irrelevant. What is the relevance of whether or not she told the defendant about these pictures later? What's the relevance of taking them if you're not going to show them to somebody?
Whether I'll agree that the question posed is whatever the answer would be does not have any effective consequence, more or less likely than it would be without the evidence, so I'll sustain that.
All right.
You agree with me that this terrible bite that you claim took place, let me just show the jury again. This is Exhibit 1. Terrible bite, and I'm going to show the jury Exhibit 2. Terrible bite left no bite mark, did it?
It wasn't there. That was 4 days later? 5 days later? Yeah, I don't know if I had it anymore.
this terrible bite that you say was there for an extended period of time and caused this pain, didn't even break the skin. Right? Am I right?
There was a little scar that was there.
Didn't even break the skin, did it?
It didn't. The bite marks were there. Did it bleed? No.
I have nothing further to this.
Redirect?
No, Your Honor.
Okay, the witness may step down and is excused. And the state may call its next witness.
State rests.
Okay. Well, members of the jury, the state having rested, we'll take a mid-morning recess at this point. Before we do so, I just want to instruct you on a few matters that I mentioned with jury selection as well. First, you're not to discuss the case amongst yourselves or with anybody else until the trial is concluded. That is, until all the evidence has been presented. I've instructed you on the law that applies to the case, and the attorneys have made their closing arguments. Accordingly, during this recess or any other recess, please do not discuss the case amongst yourselves or with anybody else. Secondly, to decide the case based solely on the evidence presented in this courtroom. Accordingly, please, between now and the conclusion of the trial and during any recess, please make every effort to avoid being inadvertently exposed to any information having to do with this case, the witnesses, the parties, or the attorneys through the internet, media, social media, or any source whatsoever. Jurors may be excused.
All rise.
Counsel, anything further before we adjourn?
Not at this time, Judge, but prior to the jury coming back, I do anticipate making a motion to dismiss. And,
Would now be a good time?
well, I could do it now.
But that was the oblique purpose of my question, so
Okay.
have a seat, everyone, and make your motion.
Thank you. I will move to dismiss this matter, Judge. Even without Jeff Woodburn taking the stand and asserting self-defense, the complaining witness herself has laid down sufficient evidence before any trier of fact, in fact you, that would support the claim of self-defense. She was the initiator of the contact. She was the initiator of the confrontation in the car. She was the initiator of attempting to restrain Mr. Woodburn. The effect of the restraint would be to maintain some control over property that was rightfully his, that would keep him from leaving the automobile on a cold December night in Jefferson, New Hampshire. That a struggle ensued, and it ensued but for the activity of the complaining witness in this case. That, in fact, any and all injuries sustained by the complaining witness in this case was initiated by the complaining witness. That, in fact, she said it herself on the stand, that her initiation, her physical activity, and the reaction thereof by Mr. Woodburn, in reaction to her physical activity, caused the bite or the physical injury that is complained of in both complaints. Both complaints. And but for that, but for her activity, but for her actions, there would be no assault, there would be no injury to a hand, there would be no bruising, there would be no biting. Period. I mean, she started it, she received a reaction to it. She cannot be a complainant. She cannot be a complainant. The physical activity started by her, and the reaction by Mr. Woodburn was not an overreaction. There wasn't any punching, there wasn't any slapping, nothing of the sort. It was a sufficient reaction to allow him to leave that particular car with his property. It was his desire to leave. It was her desire to keep him from leaving and to control that which was his. Now, the control over the item is what basically was her intent, and the control over him was her intent. He didn't leave, we heard, until he had control over the phone. So her intent, of course, could be directly inferred on keeping him restrained in that automobile. That was her intent. That was her intent. And it was his intent to leave, and that's clear from her testimony. So just from those particular facts alone, we believe that a motion to dismiss should be granted at this time. Thank you, Judge.
Attorney Spicer?
The state asks the court to deny the motion at this time. The state has presented sufficient evidence to satisfy each and every element of the charged offenses, particularly at this stage, in the light most favorable to the state, without a bar. Ms. Jacobs testified that she and the defendant were engaged and they were intimate partners. She testified that he bit her on the hand, causing bodily injury. There is photographic evidence of bruising. She testified that it caused her pain for days. I believe that Ms. Jacobs' testimony also establishes that the defendant acted recklessly, that he consciously disregarded the risk of bodily injury when he bit her. Those are the elements. The state has satisfied those elements. I would argue at this point that the defendant, at the close of the state case, has not made even the scintilla showing of evidence required to raise self-defense at this point. I understand he's going to take the stand, and I understand that may certainly change the equation. But at this point, there has not been sufficient evidence through Ms. Jacobs' testimony, certainly, that the defendant was acting in self-defense. Even if that were the case, the defendant has not satisfied those elements sufficient at this stage for dismissal of the case. For him to claim self-defense, he would have to have evidence that he actually believed he was in imminent danger of being confined or having force used upon him. There was no evidence of what he believed. There's no evidence whatsoever, certainly none that can be inferred from Ms. Jacobs' testimony. Ms. Jacobs testified that she did nothing to keep him from leaving the car. She did not lock the door. She did not say anything to him. She did nothing to use force against him. She didn't touch him. She didn't threaten to hit him. She didn't hit him, punch, slap him, do anything of the sort. All she did was reach for his phone. And she admitted why she did that, to prevent him from making a phone call. There is no defensive property in this case. That has not been noticed. So the fact that the defendant wanted his phone is of no issue here. It's a nuanced argument, I understand, but the defendant's claim of self-defense is that it would have been too dangerous for him to leave the car without the phone. There is certainly no evidence that that's the case, based on the evidence that's been presented so far. There's also, I think, certainly in the light most favorable to the state, no evidence that the defendant's supposed belief, which we have not heard yet through the evidence, that he was in danger of being confined or having force used upon him was reasonable. I think certainly it'll be a matter for argument, but biting Ms. Jacobs on the hand in the light most favorable to the state is not a reasonable thing to do. And lastly, there's the issue of whether or not that force was excessive. And I think the defendant has failed to identify any evidence in the record at this point in the light most favorable to the state that would allow him to satisfy that for purposes of motion to dismiss. Counsel seems to be arguing some sort of legal standard I'm not familiar with, where if Ms. Jacobs initiates a confrontation by reaching for a phone, she is then somehow to blame for the defendant biting her. There's no strict liability here. I'm not sure what that standard might be. But given the elements of the charged offenses, which have been satisfied, and the elements of self-defense, which certainly have not, we'd ask the court to deny the motion at this time.
Attorney Sisti, do you have a further word?
Yeah, I would, because it's an interesting reaction on the part of the state when their own complaining witness admits she didn't want him to leave with the phone. That's actual attempt at confining. That's actual confining. Forget about attempted. That actually happened. Right in the car. Through her words. He wasn't going to leave with that phone. He wasn't going to make that phone call. That was her intent. And his intent was to leave with that phone, to make the phone call. Not only is it's an actual confinement. Forget about an attempted confinement. It's in danger of being injured or confined by the other person. How could he not reasonably believe from her testimony, that she wanted him to stay in that car with that phone? Stay in that car with that phone. That phone was her leash. If she could take that phone, if she could control that phone, he couldn't come out that passenger door, the one that he was opening at the time. How does she keep him in the car? Grabbing the phone. That's confinement. There's no nuance to anything about it. It's actual. And that confinement is the very act where there was a reaction, a reasonable one, from Jeff. Not overdone, didn't cause any serious bodily injury, didn't even break the skin, by the way, of the complainant. And once he had control over the phone, he's out the door. Those are the facts.
Right, a ruling on a motion to dismiss challenging the sufficiency of the evidence at the close of the state's case. The court construes all the evidence presented and all the evidence presented and all reasonable inferences therefrom in the light most favorable to the state. If the evidence is sufficient to permit the jury to find guilt beyond a reasonable doubt, the motion should be denied. Applying that standard and construing the evidence and all reasonable inferences therefrom in the light most favorable to the state, I find that the state has presented sufficient evidence to withstand a motion to dismiss, and specifically the state has presented evidence from which the jury could find that the state has proven beyond a reasonable doubt each of the elements of the alleged offense. Accordingly, the defendant's motion to dismiss challenging the sufficiency of the evidence at the close of the state's case is denied.
Thank you.
We will take a recess.
All right. County Superior Court is now in session. Honorable Peter A. Bornstein presiding. Please be seated.
Attorney Sisti, you may call your first witness.
Thank you, Your Honor. Jeffrey Woodburn would like to testify. You just stand up there, I'll swear you in. Sure. You raise your right hand. Swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury. Please take a seat. Can everybody hear me okay? Because I heard somebody was in there. This isn't working. You good? Yeah, let's try this. How about that? Okay, I'll face for the left.
You can add a microphone if you want.
Maybe we'll take this one over here.
Do you want to just put it beside him? Between the two of them, we can make it work.
That's pretty good. That's cool. How about that? We getting there? We're going to work this out. How about that?
That's fine.
Good. Okay. All right, for the record, can you state your name and spell your last name, please?
Sure, it's Jeffrey R. Woodburn.
And Jeffrey, can you tell the folks where you live?
I live in Whitefield.
And how long have you been living in Whitefield, this area?
Since I was 6 months old.
Since you were 6 months old. Can you tell the jury a little bit about yourself, where you were educated and what jobs you've had?
Sure, I, from Whitefield, grew up there, went to Whitefield School, White Mountain Regional High School, went on to Franklin Pierce College, and done various things. I was worked in government and was a teacher at White Mountain Regional High School, was a newspaper reporter in the local area, and presently I am a bartender server at the DoubleTree in Manchester.
Okay. I want to take us back to December 15th, 2017, okay? That's what we're going to talk about, all right?
Okay.
All right. And I want to concentrate on that date and the time period of that evening into the early morning hours, all right?
Okay.
Okay. You've heard testimony that there was a party that night that you attended?
That's correct.
And for the jury, can you explain where that party was and what the purpose of that party was?
Sure. It was on Reed Road, and it was at the Crafts residence, and it was for the Coles County Democratic Committee hosted that party.
Okay. And just for clarification, there's been some reference that you were a senator, correct?
I was.
And were you a senator at that time?
I was.
And how long were you a senator from this area?
2012 to 2018.
Now, on this particular night, had you made plans with Emily Jacobs to meet at this party?
Yes, we made plans to do that.
And you heard her testify, right?
I did.
And was she accurate in testifying that the plans included that she would be a driver that night?
Yes.
And how was it that you got to that party?
I had a meeting with someone who was coming from the south. We went to Lancaster, so I carpooled with him to Lancaster, and then he dropped me off at the Crafts residence on Reed Road.
Okay. So you had a previous meeting with somebody?
Yes.
And then that individual got you to the party?
Correct.
Okay. So you were without a car?
Right.
Okay. And Emily would have known that?
I'm sorry, I didn't hear that.
Emily would have known that?
Yes.
And did you plan on meeting Emily there?
At the party, yes.
And did you plan on leaving with Emily to go to her home?
You even got to the party? That's right.
That would not have come as a surprise to Emily?
Not at all.
At the party, Emily states that you had some drinks?
Yes.
Did Emily, in fact, have drinks?
Yes.
And about what time did you leave that party?
I'm guessing probably sometime around 11 or so.
And as planned, did Emily drive?
She did.
And as you left the party, was there any problem in the car?
When we left, our argument did ensue along that road, Reed Road.
And was Emily correct in stating that she initiated the conversation?
Yes, she did.
Prior to her initiating that conversation, were things going well with you and Emily that night?
Yeah, perfectly normal.
So you're driving down Reed Road and there was an argument, right?
I didn't hear.
Started some argument.
Yes.
Okay. Did you eventually get into Route 2?
Yes, we did.
And can you just, I know the jury knows, but for the record, can you explain what Route 2 is and where Route 2 would be relative to, let's say, Reed Road?
Yeah.
And let's say, take us up to the Cabot Inn, for instance.
Sure. We left Reed Road, which the house was closer to the Route 3 side, so we drove down Reed Road, which ends up on Route 2. We took that right, heading heading east on Route 2. And somewhere in that area, and the cabin is kind of the landmark there, I asked her, the argument was going on, and I asked her to let me out of the car.
Okay. So the first time you asked Emily to let you out of the car was around where the cabin inn is, right?
That's right.
Okay. And in fact, at that point in time, did Emily pull the car over?
She did.
And that was on Route 2, correct?
That was on Route 2 in Lancaster.
And when the car was pulled over on Route 2, were you able to get out of the car?
I got out of the car and started walking towards Lancaster.
At that point in time, did she try to restrain you in any way, shape, or form?
No, she did not.
And what was your intent when you got out of the car?
My intent was to get out of the car, get out of that escalating situation, and to call a friend to pick me up.
And in fact, did you initiate a phone call?
I did.
Okay. And who was the individual that you called?
I called her McGrath.
Now, after you initiated that phone call, did you end up getting back into the car?
Yes, after the phone call was made, Emily came out of the car, turned the car around because I was heading towards Lancaster, and convinced me to get into the car. I then canceled with a text, the message or something, with R saying, "We're not getting together, come back in the car."
All right. So Emily turned the car around, drove a short distance, asked you to get back in the car, right?
Correct.
And then I guess you headed back toward Jefferson.
We headed east towards Jefferson.
Still on Route 2.
Still on Route 2.
All right. Now you're traveling east towards Jefferson. And where's the destination that you're intending on going?
Highfield Lane.
And had you intended on going there all night?
Yes.
And would that have come as a surprise to Emily?
No.
As you're driving towards that particular destination, does an argument start up again?
It does. It continues. It starts out again.
And does the car actually make it to her road, this road that we're discussing?
It makes it to the entrance of, yes, Highfield Lane.
All right. And do you travel a short distance down Highfield?
Correct.
Now, there was a map, and there was a depiction of the site. And for the record, this will be marked as Exhibit 3. I'm going to show you Exhibit 3, Jeff, and ask you for a couple of landmarks. And then I'll ask you to point to where you believe the automobile pulled over, okay?
Okay. Yes.
And with the court's permission, could Jeff leave the stand so we can show the jury the exact location?
You may.
Thank you. Okay. I'm going to keep our voices up here. We don't have a mic. But this is Exhibit 3. You recognize that? Yes, I do. Okay. It's got certain addresses marked on it. First of all, can you just point to where Emily's house would be?
That is right here.
Okay. And you pointed to 144 Highfield, right?
Yes, I did.
It's for the jury. You'll have this back. And as a point of reference, can you show the jury where Route 2 is?
Route 2 would be yellow here.
This yellow line is cutting diagonal. Route 2. All right. Now, we've got Route 2, we've got 144 Highfield. Can you show the jury approximately where that car eventually pulled over?
I believe that is the red house. Is a red house and has fields on either side. It would just be on that red house. So it can 76, I believe it is.
Right here?
Yes.
Okay. Right about here, folks. 76. A little beyond. Okay, don't you grab a seat there? Okay, Jeff, you get to that point of reference that we just showed the jury, and at that particular point, did you make your desires known to Emily?
Yes, as the arguing continued, I asked to be let out of the car.
And did you in fact attempt to get out of the car?
I did.
All right. Now, why don't you explain again? Now, were you in the passenger seat?
I was in the passenger seat, yes.
The front right passenger?
Front right passenger seat.
All right. And Emily would have been in control of the vehicle, correct?
As she was driving, yes.
With the vehicle stopped, what did you do to try to get out of the vehicle?
We were driving up Highfield, and I asked her to stop. She did not. I grabbed at the steering wheel and pulled it to the right, which caused it to veer off, and she hit the brakes and stopped the car.
Okay. As the car's over to the right, do you then attempt to get out of the car?
I opened the door and attempt to leave.
Okay, so in fact, the passenger door was open a bit, correct?
That's correct.
What kept you from leaving that car?
There was a struggle over the phone. We had an argument about what I was going to do, what my plan was. I said I was going to leave, call her to pick me up, and she then grabbed the phone and a tug of war ensued.
All right. So she physically placed her hand on you and your phone?
Definitely the phone, possibly my hand, because it was in my hand.
All right. So can you show the jury which hand the phone would have been?
And I'm opening the door with my right hand, and I have the cell phone in my left hand.
All right.
And so it's sort of near the console area, I guess, but I'm moving out, the door is open, and she grabs the phone, and we struggle over the phone.
And you struggle over the phone, and how long did this struggle take place, if you recall?
I mean, it's probably seconds, and not long, but you know, it all happened very fast. But I can't imagine it was many seconds. It was a struggle. I mean, it was not. We pulled back and forth, and there was a desire and an effort to her to pull it her way and me to pull it my way, and it was two hands. So there was the back and forth. So maybe a minute, but not long.
Were you going to be able to leave that car with your phone the way things were going?
Well, my plan was to leave the car, make the telephone call, and that changed when the struggle started, when she grabbed my phone. And I felt I needed the phone because of the weather, because of the conditions, walking out. It was just, I couldn't do what I intended to do, which was call somebody to pick me up without my phone.
Now, during this struggle, all right, did there come a point in time where you bit her?
Yes, as we were doing the tug of war, I bit her left hand to try to create enough pressure for her to let go, which worked. And
as soon as she let go, and as soon as you were freed, did you leave?
I did.
Did you punch her
I did not.
Did you slap her?
No.
Did you strangle her? Do anything like that?
Both my hands were on the phone. I wasn't going to let go.
Was she going to let go?
I don't believe so.
Sustained. The
What
answer
was
is
her-
stricken from the record. The jury's instructed to disregard it.
What was her position on your hand and your phone? Here, let me give you a phone.
Yeah.
You just show the jury.
So opened the door with the right, so it would have been in this hand, and then she grabbed it, and then there was, I had two hands on hers, and she had two hands, so her hands were under my hands, so that was the two-hand struggle, both of us using two hands.
And during that struggle, that's when the biting took place.
Correct.
And as soon as you were released and able to leave the car, you did.
I'm sorry,
As soon as she released, all right, and you were able to leave the car, you did.
Yes, as soon as I got control, I left the open door.
And when you got outside, did you threaten her in any way, shape, or form?
I did not.
Were you screaming at her or anything?
I was not.
Did you then initiate another phone call?
No, I think I started to, but then I started walking down a Highfield Lane, and she came out, and at that point, I turned the phone off. No phone call occurred. I did not reach Art at that time.
Where were you heading?
Where was I at that time? Where was I headed? I'm not really sure. I was heading away from her, and that would be, which direction was I heading? I guess that would be south, I guess, towards Route 2.
Okay, so you were going back to Route 2.
Correct.
And what was your intent at that point in time?
My intention was, it was all very fast what was going on. My intention was just to be happy to be out of there, having my phone, and to find a way to get someone to pay me out and be able to get me out of that situation.
Can you describe the setting that you were in physically? What was it like there?
It's a Highfield, it's a mountainous kind of road, and it's unlit. It's got several long driveways that run off that Highfield. It's an incline. It's the snow or ice on and it was a mid-December, so I don't know what the temperature was, but it was cold. I wasn't dressed in any way to be going out for a hike off a Highfield Lane that night.
And that was it? Why you wanted to make a phone call?
I wanted to make a phone call to get out of that situation.
Did you have boots on and gloves and stuff?
I did not have boots or gloves.
Did you even have a hat on?
Did not have a hat.
Sweatshirt or anything?
No. Whatever I wore that day to the meeting would have been probably business casual.
Was your intent at all that night to do any harm whatsoever to Emily Jacob?
No.
I really have no further questions, Jack.
Thank you.
State may inquire.
Thank you, Your Honor. Good morning.
Good morning.
Testified just a minute ago that you needed your phone to leave the car.
I needed the phone to get out of that situation.
So you couldn't leave that car without your phone?
Physically, could I have left that car without my phone? Yes, I could have left without my phone.
Well, essentially you're telling the jury that you didn't feel safe leaving the car without that phone, right?
That is correct.
So your testimony today is you needed that phone to keep yourself safe.
I needed that phone to do what I said I was going to do, is to call a friend to pick me up when I'm in the middle of the night, in the middle of December, in a place that I didn't feel I could safely leave.
So to keep yourself safe.
I'm sorry, I
To
didn't.
keep yourself safe. Because it
Yes.
wasn't safe for you to get out of that car without your phone. Is that right?
That is correct.
So your intent that night, or what was in your mind, was that you couldn't leave that phone without your car, right?
I'm sorry, I couldn't leave the phone.
So in your head that night, on December 15th, on Highfield Lane, it's dark and it's cold. In your head, you're telling us today that you thought, I cannot leave this car safely unless I have my phone.
Yes,
And in fact, you did get out of the car, right?
correct.
So after this tug of war that you described, and after you bit Miss Jacobs on the hand, you got out
When I secured my phone, I did get out.
by biting her in the hand to
Correct.
to release it.
Yes,
And you testified just a minute ago, once you got out, you started walking,
correct.
and you turned your phone off.
No,
You didn't just tell this jury that you turned your phone off?
no.
So you didn't turn your phone off.
I did not turn. I called Art again, and I hit end before he picked up.
Is that what you just told us?
Yes.
In response to a question from your lawyer? You're telling us now that you called Art.
I did not reach Art. I made a phone call and I canceled it.
Okay, so you didn't turn your phone off.
I did not turn my phone off.
You've never said that.
If I did, it was misspoken, but I did not turn my phone off.
Okay. You started walking towards Route 2.
Correct.
Okay. Mr. Woodburn, you testified about this incident at a previous hearing. Isn't that right?
Correct.
And at that previous hearing, you took an oath to tell the truth. Do you remember that?
I did.
Just like you took an oath to tell the truth here today.
I did.
And at that hearing, you said you were going to get out of that car on Highfield Lane on December 15th with or without your phone. Isn't that right?
That's correct.
Okay. That's very different from what you just told the jury today.
In the previous hearing, I was asked would I leave without.
Judge, my question was, you testified at a previous hearing, you were going to get out of that car with or without your phone, right? You just told me that you needed that car to get out of your phone.
My
Just the
test-
phone to get out of your car.
I
Is
tell you
that right?
I got 3 questions there, Judge.
Yeah, well, let's back up and start over again, but the witness needs to answer the question that's posed to him. So whatever that question is, listen to it carefully and then answer that question.
Well, sir, you admitted just now that during your previous testimony, you said, I was going to get out of that car with or without my phone. Is that what you just told me?
I'd like to answer that question about what my testimony was.
I can show you your testimony, but I'm going to ask you the question based on your memory. Did you previously testify to the effect of, I was going to get out of that car with or without my phone?
I did. That was my goal.
And today, you testified that you couldn't get out of that car safely without your phone.
My testimony said my goal was to get out of that car and I needed
I
my
asked you
phone.
about your testimony today, sir.
My testimony today was that I needed my phone to get out of the car, and that's consistent with my other testimony.
Okay. You also testified about biting Miss Jacobs at that previous hearing. You remember that?
I did.
And at that previous hearing, you testified, I don't remember the details, I just know I bit her.
There were a lot of questions I did not remember, and I don't remember in that case. I told you I answered the questions today, telling you what I did remember, not what I don't remember.
Well, my question was, did you previously testify, I did bite her, but I don't remember the details?
If that's what the testimony said, but the entirety of it, I think, is clear.
Well, we're looking at transcript professional memory.
Please.
Page number.
185. Thank you. You see the highlighted portion there? Please take a read and let me know when you're done. So I'll ask you again. Did you testify that yes, I did bite her, but I don't remember the details.
I did say that, and I said a whole lot of other things.
I'm just asking about that right now. And that was sworn testimony. And then you were asked if you lost that tug of war over the phone, would you still have gotten out of the car in December by yourself? Remember that?
I do remember that.
Do you remember what your answer was?
I remember my answer was my goal was to get out of the car, absolutely, and I needed my phone. I felt it was a bad situation. I needed my phone to accomplish that. But yes, my goal was to get away from that situation.
Well, let's have you refresh your memory here. Look at page 186 now.
Yeah, that's it. Yeah, absolutely.
So when you were asked, jeez, heavy body. When you were asked if you lost that tug of war over the phone, would you still have gotten out of the car in December by yourself on the side of the road? The first words you said were absolutely. I mean, yeah, my goal was to get out of the car.
I was trying to get away from her, get away from that situation. Yes, that my goal was to get out of the car, and I clearly stated there that
No,
not
I'm
having
not
a
asking
phone.
about anything else you said
Okay.
right now. You asked again about that later on in the hearing. Do you remember that?
I don't recall.
Remember being asked about, I'm talking about within the context of that previous hearing, you were asked, and you also testified you were getting out of that car with or without your phone, correct? That was your testimony?
Correct. Yes.
What was your answer?
Was yes.
Yes, that's correct. Your
Yes,
answer was that was my testimony, correct?
Yes.
So you agreed. You were getting out of that car with or without your phone.
Yes, that's what I said.
Can you show the jurors your hands, please? Thank you. How tall are you, sir?
6'2".
Are you ashamed of biting Ms. Jacobs?
I am ashamed of the situation. I'm ashamed of the relationship, what happened. And that night, I firmly believe I did what was necessary and reasonable under the circumstances.
So that's what you're telling us today?
I'm telling you that things change over time in terms of how you do things. And I felt very ashamed of this whole process. And so yeah, I felt a lot of shame. And still do. That doesn't mean that I didn't feel like I did what was necessary at that time.
It was wrong to bite Ms. Jacobs, wasn't it?
It was not.
You remember at that previous hearing being asked about the bite?
I do.
Okay. And you were asked, it's not logical and rational to bite someone, is it?
No, it's,
Do you remember what your answer to that question was?
I do not. Probably yes.
Well, let's see. In fact, when you're asked whether it was logical and rational to bite someone at that previous hearing, you testified that you were ashamed and that it was not the proper action to take. Is that right?
That's what I said.
I have no more questions.
Attorney Sisti, redirect.
Yes, I appreciate it, Jeff. Let me get into a couple areas, Jeff, that the prosecutor didn't want to get into on page 186 of the prior testimony. Because maybe we should put this in a little context, right?
Yes.
The question, I believe, that the prosecutor was referring to in the prior testimony was, if you lost that tug of war over the phone, would you still have gotten out of the car in December by yourself on the side of the road? I believe that's the question that he was referring to in the prior testimony.
Okay.
Okay. First of all, you'd agree that even in that prior testimony you described the activity as a tug of war, right?
I did.
And by that, is that absolutely consistent with what you just showed the jury?
Yes.
And would your entire answer have been in that prior testimony after that question? Let me read it again. If you lost that tug of war over the phone, would you still have gotten out of the car in December by yourself on the side of the road? That was the question. And your full answer to that question was absolutely. I mean, that was my goal, was to get out of the car. I felt not having the phone was a problem. And it's a long walk to anything from there. Remember that answer?
I do.
Were you concerned about your safety that evening?
I was.
Is that why you needed the phone?
Exactly.
And let me ask you something else, okay? The question back then on page 186 was, okay, so in terms of the tug of war, did you have one hand? She had one hand? Was it both of you using both hands? Describe that as best you can.
Objection.
Basis?
Reproach.
Yep.
I'm objecting on hearsay grounds. I don't think there's any sort of...
I'm sorry, go again.
I'm objecting on hearsay grounds. This is not rehabilitation by prior consistent statement.
Yeah, it is, because that's the full context of where he cherry-picked that.
He testified that he had two hands on the phone. Asking what he testified about previously is not... they haven't been impeached on that. There's nothing to rehabilitate. I had to challenge him on that. It's hearsay, and there's no exception.
It's not hearsay.
It's his own statement, it's hearsay.
It's in the total context of what that particular specific...
It's a different topic.
It's not. It's the tug of war you referred to in the beginning of the question.
The context of the question was about whether or not he would have gotten out of the car. On the issue of the tug of war of the phone, he's not been impeached.
Sustained objection. It's out of court statement offered by the witness and not Ms. Laredo.
With regard to your prior testimony, with regard to your recollection of what took place, you did know that you bit her, right?
Correct.
Just like you told the prosecutor, right?
Correct.
Did you explain the details then?
Yes.
Approach again.
Same objection, Judge. This is hearsay. He's asked about whether or not he admitted to biting her. He did. That's fine. But asking, did you explain the details back then? When he's previously testified, I don't remember the details. This is not rehabilitation.
Yeah, but while you're explaining why it's admissible, let me look at the...
Yeah, right there. Yes, Your Honor.
19 to 25, let me just read it. And I'll do what you say.
Explain.
And so do you want to just end with line 23?
Yes. Yes, I want to end down there. Yes. This bracket. And end at 23.
End at line 23?
That's fine.
Yes.
I mean, that I agree is
That's fine.
for the purpose of completeness.
Thank you. Okay, so you got into some details and you relayed in that prior hearing what your recollection was, right?
That's correct.
All right. Would it have been? I mean, it was just so fast. But I know that struggle. I was trying to get away. And I did. I did. I believe I did do that. That referred to the bike, remember?
Correct.
And your intent was to get away, right?
Correct.
And once you were able to get away, was there any further physical contact?
There was none.
I have no further questions. Thank you.
Any requests?
No.
Okay, the witness may step down.
Thank you, Your Honor.
And Attorney Sisti, the defense rests, I'm guessing?
You got a great guess, Judge.
Okay, thank you. Would counsel approach a moment? No rebuttal, right? So we're ready to instruct afterwards. Okay. The wanted to send instructions out a week or so ago. Any objections?
No, they're okay.
Okay. Well, then we'll break for lunch. We'll recess for it's 11:42. So we'll get back at 12:50. Give them an hour and 5 minutes or so, and I'll instruct, and you'll argue that I'll give you the final instructions.
Are they going to get a copy?
Of what?
The instructions?
Yeah.
Okay,
They
good.
usually get...
I know, but it's like, I know, but I'm in from county to county.
No, they'll get, I believe it's 2 copies.
Do you have another motion?
You can correct me on that.
Yeah.
Could we just do that now?
Yeah, I'll renew the motion at this point in time, Judge, with the standard as it is at the end of all the evidence.
Okay.
Self-defense has been
Yes,
induced.
the state objects.
That's correct, Judge, for the reasons identified before.
Through the evidence, the totality of the evidence at the close of both the state's and the defense's case, I still find that there is sufficient evidence from which the jury could find the state's proven each of the elements of each alleged offense beyond a reasonable doubt, so the motion to dismiss based on the sufficiency of the evidence at this stage is denied.
Thank you, Your Honor.
Okay, members of the jury, the defense having rested as well, that concludes the presentation of evidence. So we're going to recess for lunch in a moment. Although the presentation of evidence is concluded, bear with me a minute. The case isn't over yet. That is, after lunch, I will instruct you on the law that applies to the case. Then the attorneys will make their closing arguments, and then you'll retire to deliberate a verdict in this case. So again, although it's almost over, it's not over. So during the luncheon recess, as I said before, please don't discuss the case amongst yourselves or with anybody else, and please make every effort to avoid being exposed to any information from any source whatsoever having to do with this case, the witnesses, the parties, or the attorneys. So we'll break for, let's say, an hour and 5 minutes. Plan to be back by 12:50, if you would, and the jurors may be excused.
All right.
He instructs first, so you can go. He's going to...
Coles County Superior Court is now in session. Honorable P. 14 presiding. Please be seated. Thank you.
Okay, members of the jury, the evidence in this case has been completed. Now I will instruct you on the law that applies to the case. Then the attorneys will present their closing arguments, and you will retire to decide a verdict in this case. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you must understand the definition of the crimes with which the defendant is charged. You must understand how convinced one way or the other you should be before you reach a verdict, and you must understand what to consider in order to decide whether or not to believe a particular witness. These instructions will explain the law as to these and other matters so that you can arrive at a just verdict. It is your duty as jurors to follow all the instructions that I'm about to give you. Regardless of any opinion that you may have as to what the law is or ought to be, the law as I explain it to you is the law that you must follow in reaching a verdict. It is up to you to decide the facts in this case. You must decide the facts solely from the evidence in this trial. You must apply the law given you in these instructions to the facts as you find them, and in that way reach a fair and a just verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented and the law as I instruct you on it. The fact that the defendant has been arrested and charged is not evidence of guilt. The complaints are simply a way of giving the defendant notice of the charges against him. The complaints are a formal way of accusing the defendant of a crime in order to bring him to trial. You must not consider these complaints as evidence of his guilt. The possible punishment if you render a guilty verdict should not influence your decision. The duty of imposing sentences for the judge. You should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. You will hear the lawyers discuss the facts and the law in their arguments to you. These arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers state the law differently from the law as I explained it to you, then you must follow my instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from the way in which you recall it, then you should follow your own memory of what the evidence was. During your deliberations, you should only consider the evidence in this case. The evidence consists of the testimony under oath of the witnesses and any exhibits which have been admitted into evidence. During the trial, the lawyers made objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustained an objection or excluded any evidence, you must not guess as to what the answer or the evidence would have been. If I ordered that a question and answer be stricken from the record, you are not to consider either the question or the answer as evidence. In addition, if I allowed some information to be entered as evidence after hearing objections by one of the lawyers, you are not to give such evidence any special importance as a result of my ruling. It is not my duty, and I certainly did not try to determine whether evidence was important or significant when I made my rulings regarding admissibility. If you believe that I've expressed or suggested an opinion as to the facts of my rulings, you should ignore such an opinion. It is up to you alone to decide the facts in this case. In short, you should consider only the legally admissible evidence in deciding this case. That is, the testimony under oath of the witnesses and any exhibits which have been admitted into evidence. Now, there are two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. Let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. If you look outside and see water droplets falling from the sky, that is direct evidence that it is raining. But if you look out the window at night, the ground is dry, and again the next morning and the ground is wet, that is indirect or circumstantial evidence that it rained during the night. That is all there is to circumstantial evidence. On the basis of reason and common sense, you infer from an established fact the existence or non-existence of another fact. You should consider both types of evidence. There is no legal distinction between a way of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give to any evidence, whether it be direct or circumstantial. However, there is a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of the charged offense, then in order to convict, you must find that the totality of the evidence excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. Therefore, if there is a conflict between witnesses who offer direct evidence concerning certain facts, you should resolve the conflict. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, should resolve the conflict and must decide whether, based upon all the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. In summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. Now, under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent person, and you must consider him to be an innocent person until the state convinces you beyond a reasonable doubt that he is guilty of every element of the alleged offense. If, after all the evidence and arguments, you have a reasonable doubt as to the defendant's having committed any one or more elements of the offense, then you must find him not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or a fanciful doubt, nor is it one that can be easily explained away. Rather, it is such a doubt based upon reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, then you must find the defendant not guilty. However, if you find that the state has proven all the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. In deciding whether the state has proven the charge against the defendant beyond a reasonable doubt, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict and decide what the truth is. Simply because a witness has taken an oath to tell the truth does not mean that you must accept the testimony as true. In deciding which witnesses to believe, you should use your common sense and judgment. I suggest that you consider a number of factors. Whether the witness appeared to be candid, whether the witness appeared worthy of belief, the appearance and the demeanor of the witness, whether the witness had an interest in the outcome of the trial, whether the witness had any reason for not telling the truth, whether what the witness said seemed unreasonable or inconsistent with the other evidence in the case or with prior statements by the witness, and whether the witness had any friendship or animosity towards other people in the case. In deciding which witnesses to believe and how much of the testimony to believe, you should consider both the direct and the cross-examination of that witness. You should consider these factors in deciding the credibility of all witnesses. In short, you should consider the testimony of each witness and give it the weight that you think it deserves. You can accept all of what a witness has said, you can reject all of what a witness has said, or you can accept some of it and reject some of it. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity of the evidence. It is not the number of witnesses or quantity of evidence that is important, but the quality of the evidence that is important. In deciding whether you believe a witness, you may consider whether the witness made statements before trial which were not consistent with what the witness said at trial. If the witness made an inconsistent statement before trial, you may use that statement in deciding whether to believe that witness. You may not use a statement made before trial as proof that the facts in the statement are true. The statement made before trial is only to be used by you in deciding whether to believe a witness. There are, however, two exceptions to this general rule that prior statements may only be used in assessing witness credibility. If the statement made before trial was made by a party or by a witness under oath, then you may use the prior statement as proof that the facts in the statement are true. Now, each of the charges against this defendant constitutes a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on any one of the charges should not influence your verdict with respect to the other charge. It's important you understand what a crime is. A crime is any breaking of the law for which the law provides punishment. All crimes have at least two parts. First, a criminal state of mind, and second, an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his state of mind was. The phrase state of mind refers to what a person mentally believes his physical acts will accomplish. The word act refers to a physical deed. Thus, for a person to be guilty of a crime, he must have done the following two things. First, he must have had the required state of mind, and second, he must have physically acted to do something that is criminal. Unless a person both had the required mental state and acted to do something criminal, that person has not committed the crime. This means that if a person either did not have the required mental state, or if a person did not physically act to do something criminal, then he is not guilty of a crime. Remember that the reason crimes are given different names is that each refers to either a different mental state, or to a different act, or to a different mental state and a different act. Many persons do not realize that sometimes the only reason two identical acts are given different names is that they refer to different mental states. For example, let us assume that two drivers of automobiles hit someone crossing a street. If one of the drivers intended to hit the pedestrian, whereas the other one did so out of carelessness, they would not be guilty of the same crime because they had different mental states. Thus, you can see how both the act and the mental state can make a difference. Now, next I want to instruct you on the two specific offenses with which this defendant is charged. In the first complaint, ending in charge ID 54C, the defendant is charged with the crime of simple assault. The crime of simple assault with which the defendant is charged in this complaint has two parts or elements. The state must prove beyond a reasonable doubt each of the two elements of the crime. Thus, the state must prove that, first, the defendant caused bodily injury to another person. In this complaint, the state alleges that the defendant bit the alleged victim on her left hand, resulting in bruising. And then the second element is that the defendant acted recklessly. Bodily injury means harm to the body of another person. Now, part of the definition of the crime of simple assault with which the defendant is charged in this complaint is that the defendant acted recklessly. To prove that the defendant acted recklessly, the state must prove, first, that the defendant was aware of a substantial and unjustifiable risk. This means there must be proof that the defendant knew there was a substantial risk that his conduct would cause a particular result. Second, if the defendant was aware of the risk, there must be proof that the defendant consciously disregarded the risk. In other words, the defendant decided to disregard the risk and took a chance in doing certain acts that a particular result would occur. Third, you must examine the circumstances known to the defendant. From what he knew of the circumstances, you must decide whether his disregard of the risk was a gross deviation from what a law-abiding person would have done. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find that the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from the actions of a law-abiding person under the same circumstances. It is not enough for the state to prove that the defendant acted negligently. That is, it is not enough to prove that the defendant failed to become aware of the risk involved. The state must prove that the defendant was aware of the risk and consciously disregarded it. Whether the defendant acted recklessly is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted recklessly. In the second complaint, ending in charge ID 53C, the defendant is charged with the crime of domestic violence simple assault. The crime of domestic violence simple assault has three parts or elements. The state must prove beyond a reasonable doubt each of the three elements of this crime. Thus, the state must prove that, first, the defendant caused bodily injury to another person by the use of physical force. In this complaint, the state alleges that the defendant bit the victim on her left hand, resulting in bruising. The second element is that the other person was the defendant's intimate partner, and the third element is that the defendant acted recklessly. The term intimate partner means a person with whom the defendant is currently or was formerly involved in a romantic relationship, regardless of whether or not the relationship was sexually consummated. The terms recklessly and bodily injury have the same meaning as set forth above in the instruction on the first offense. Next, I'll instruct you on the defense of self-defense. Evidence has been presented that the defendant acted in self-defense. When there is some evidence of self-defense, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. In deciding whether the defendant acted in self-defense, you should consider all the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. Now, the term non-deadly force is defined in relevant part in this case as any assault or confinement which does not constitute deadly force. Confinement means the act of confining or state of being confined, restraint within limits. Now, a person has the right to use non-deadly force on another person to defend himself if, first, he actually believed that the other person was about to use unlawful non-deadly force against him. In other words, the defendant could use non-deadly force if he actually believed that he was in imminent danger of being injured or confined by the other person. Second, even if the defendant actually believed that such danger existed, his belief must be reasonable. In other words, there must be reasonable grounds for the defendant to believe that the other person was about to use unlawful, non-deadly force against him. Self-defense does not require an actual danger to the defendant. Rather, the defendant must reasonably believe that the other person was about to use unlawful, non-deadly force. Third, the defendant must reasonably believe that the amount of force he used was necessary for self-defense. A person is not permitted to use excessive force in self-defense, only a reasonable amount of force. The defendant can use the amount of force which he believed was necessary under the circumstances, as long as, at the time, there was reasonable grounds for his belief. A belief that is unreasonable, even though honest, will not support the defense. So by way of summary, in the first complaint, in which the defendant is charged with the crime of simple assault, the state must prove beyond a reasonable doubt three things. The defendant caused bodily injury to another person, and the defendant acted recklessly, and the defendant did not act in self-defense. In the second complaint, in which the defendant is charged with the crime of domestic violence simple assault, the state must prove beyond a reasonable doubt four things. First, the defendant caused bodily injury to another person by use of physical force. Second, the other person was the defendant's intimate partner. Third, the defendant acted recklessly. And fourth, the defendant did not act in self-defense. And defense counsel may make your closing argument.
Thank you, Your Honor. Thanks. If you guys can't hear me, raise your hand.
You just have to be closer to the mic.
Okay.
That's all.
Okay, I'm going to work this out with you. Here we go. How's that?
There you go.
All right. Good. I want you to hear me. It's important that you do. And I want to thank you for sitting in on this. Now, I know it didn't take a long time to put the case in, but cases in criminal courtrooms are extremely important. Before you label an individual a criminal, you have to work real hard through the facts and the instructions that the judges gave you. And in this case, I told you earlier this morning that if you would just embrace the facts and the law, it's going to lead you to the path of an acquittal. And I want to tell you why right now, okay? I mean, you got to hear it. The whys are really based on what Judge Bornstein just told you. The principles of law in this state, like the rest of the United States, are really based on the presumption of innocence, proof beyond a reasonable doubt, and frankly, in this case, just what the definition of a crime is. Sounds simple, but it's a little bit more complex. What was the intent? And what was the act? And then in this case, you have presented to you yet another factor, and that is self-defense. And self-defense, folks, like I said this morning, it doesn't rise and fall on the size of the individuals, whether it's a woman and a man. It's got nothing to do with it. And you didn't hear that in that instruction, did you? It has to do with the circumstances as they were presented, in this case to Jeff, on December 15th, 2017. And let's go through some of that. But we're not here to determine whether or not these two adults acted like stupid idiots, because then I think both the prosecution and the defense would say, go back into the deliberation room and come on out really quick with a verdict that they both acted kind of stupid. But that's not where we are, okay? This is much more serious stuff. This is about whether you're going to label somebody a criminal. It's not how tall you are, whether you're standing up. It's not how tall you are when you're sitting down. It's about what happened that night. I'm going to ask you to sit back, think about a few things that I'm going to present to you. How about who started this stupid mess? Think about that for a second. Think about who took the stand and said, she did. Think about who took the stand and said, she knew exactly what the plans were on December 15th, 2017. Think about that for a second. Think about it. Was it Jeff that started that? No. She knew exactly what the plans were. Party, drive back to the house, get up in the morning the next day. She also knew Jeff was going to be drinking, but we'll get into that in a second. So who initiated the argument on the 15th of December 2017? Ladies and gentlemen, you can go back in the deliberation room right now and come out in 2 seconds, and you know what the answer to that is. So factor that. That's a circumstance that the judge was talking about. That's the context of what we're talking about. Who was in control of the car? Who controlled the events of that evening? Was it Jeff? Or was it Emily? We know who it is. You can go back in the deliberation room right now and come out in 2 seconds with that answer. That's easy. Who wanted it her way? Who wanted it her way? Emily Jacobs wanted it her way. Who wanted to control Jeff? Who wanted to confine Jeff? Jeff wanted out, not in. He wanted out. He wanted to just take it down, ease it out, disengage. Who wanted to control what Jeff was going to do? You know? He couldn't even control his own phone as far as she's concerned. Who grabbed the phone? Who made the first move? Who actually said on the stand there wouldn't have been a bite without her starting this whole struggle? We already know that. And when you go back and you're thinking about what was going through Jeff's mind was he's sitting there going, boy, I want to do a criminal act tonight. I want to get in a jam tonight. I want a physical struggle tonight. He didn't pick this fight. He didn't pick this fight. She initiated the first move. She made the first contact. And there was a struggle. We're going to get into that a little deeper, too, in a moment. Who started the tug of war? And ladies and gentlemen, that was a tug of war. And you know what happens in tugs of war? One side tries to control the other. One side tries to keep somebody from going someplace they want to go. And that's exactly what happened inside that car in the late evening of December 15th, 2017. And you know it. And you know you could go back in the deliberation room and come out in 2 seconds with that verdict. But there's more. It just keeps coming. Who claimed an excruciating, painful bite? I'm going to show you a couple photographs, and then we're going to talk about common sense. And we're going to talk about why, in this country, they pick 12 jurors to sit together in a deliberation room because they get to use their common sense and their experiences as human beings throughout their life to make certain judgments. Okay? Excruciating, long-term human bite. You're going to get these. Exhibits 1 and 2. Exhibits 1 and 2 that show no bite mark. Exhibits 1 and 2 that your alleged victim even said didn't break the skin. Exhibits 1 and 2 that left no mark for you to see on close-up photographs. Exhibits 1 and 2 that required no medical attention. Exhibits 1 and 2. 1 and 2 that showed bruising but no bite mark. Now I suggest that the bruising itself probably wasn't even caused by the bite, since there wasn't even any infliction or discoloration or suggestion of a disruption bite mark. It was probably the extent of the struggle, the tug of war that was going on in the car. You don't see a bite mark. Did Jeff bite her? Yep. And that's when she finally released her grasp on him and the phone, and he was able to leave the car. That's what that shows. That doesn't show a deep bite. Didn't even break the skin. Not even a Band-Aid was used. By the way, she said no blood. I've never been in a trial in an assault case. I suggest that you will never be either in a real assault case where the alleged victim started the assault by assaulting. All right.
Objection.
Approach.
Facts, not evidence. There's no evidence that Ms. Jacobs assaulted the defendant.
There was two.
There's no evidence that Ms. Jacobs assaulted the defendant.
There was two. There's unprivileged physical contact with him. And I can argue that from the facts.
I mean, there's a dispute of testimony as to whether she touched him or didn't touch him, whether her hand was reaching toward him when he pulled away and bit her or whatever. But there's enough facts and evidence that the argument Attorney Sisti's making is a permissible inference from the facts and evidence.
Thank you. As I stated, a purported victim that's complaining about assault, that started the assault by assaulting. Do you think any of that contact on Jeff was consensual? Do you think he said, grab my hand, grab my phone, struggle with me? You think he wanted that? Was that his intent? No, it was her intent. Her intent. And now she complains about being hurt? Don't start fights. Don't start confrontations. Don't try to keep somebody in a car that wants to leave. Don't try to stop somebody from making a phone call. Don't interfere with somebody's freedom. Ladies and gentlemen, I would suggest that anybody came up to you and without permission, consent, or privilege, grabbed your phone, made contact with you first, your person, I would suggest you would react. And you properly should. And that's what the law is in this state, and frankly, probably every state in the United States. And it should be that way. It should be that way. And I'd also suggest that you'll never be on another jury or hear another case where somebody initiates the contact, engages in the struggle, then, shortly thereafterwards, apologizes for her act, and then claims to be the victim. Apologizes for her act, invites the perpetrator back into the car, and goes blithely down the road to spend the evening without calling the police, without getting checked out by a doctor. That's your case. Remember, you didn't come in here and take your common sense and flush it down the toilet. That's what really happened in this case. That's what really happened. Proof beyond a reasonable doubt? A criminal mind, a criminal intent, and a criminal act? No, a circumstance he never wanted to be in, a circumstance he got out of, a circumstance that never should have happened, maybe stupid, but certainly not a crime. Let's talk about witness credibility for a second. Because I'm sure you folks probably felt it too. But she went to a party. She knows drinking was going to go on. And she's claiming she didn't have anything to drink. Well, I guess we'll just take it from her, if that's what she wants to say to you. But sometimes credibility is tested in a lot of different ways. Kind of funny ways that can sneak up on you sometimes. And in this case, you got a gift. So you can determine some credibility on a pretty interesting factor. A woman that's lived in this area all her life, that's traveled Route 2 east and west, probably dozens, maybe hundreds of times.
A woman that has a house in Jefferson, grew up in and around Whitefield, knows Lancaster, knows Route 2. A woman, ladies and gentlemen, that this morning took an oath, looked you in the face, and said she doesn't know where the Cabot Inn is. That's who you had on the stand this morning. That's who you had on the stand this morning. She probably doesn't know where Santa's Village is either. She merely lived here her whole life. She's not being straight with you. You wouldn't believe her. If somebody came up to you and said, I have lived in Cass County almost my entire life. I've been back and forth to Gorham. I've been to Lancaster and Whitefield. And looked you in the eye and said, I don't know where the Cabot Inn is. What would you say? What would you think? Why would somebody say something like that under oath in a courtroom in something as important as a criminal case? It's one thing maybe saying, I don't remember that night stopping in front of the Cabot Inn. Maybe. But that's ridiculous as well. But to look you in the eye and just completely deny the existence of that particular structure in this particular county, in this neighborhood, is absurd. And that shows you about credibility more than just about anything. I never drank at a party. I don't know where the Cabot Inn is. We never stopped there first. He didn't make a phone call there first. Ladies and gentlemen, I suggest she didn't want to tell you the truth. She doesn't want to tell you the whole truth. But what she did tell you is good enough. What she did tell you is good enough. But you can't trust her. And you have to trust her beyond a reasonable doubt to wipe out the defense of self-defense. You have to trust her beyond a reasonable doubt. And there's no way. She gave it up herself. She gave you every possible element of self-defense, all by herself, without Jeff even taking the stand. She started it. She started it with the first contact. She started it for a terrible reason, not a legitimate reason. Victim? No. You know, in this case, you're going to have the instructions, and the instructions tell you, you don't use sympathy, you don't use passion to decide cases, not in criminal courtrooms. That's off limits. You don't do it. What you do is you use the facts. You have to be objective. You have to have an understanding of what the facts are. And you have to have a true understanding of what the law is. And in this case, there's no criminal intent. In this case, there's clear self-defense. In this case, the prosecution is held to the impossible task because of the evidence that's been placed before you to eliminate self-defense as a legitimate defense. You don't decide cases, and you all agreed last week. You know? It's not a matter of probabilities. It's a matter of proof beyond a reasonable doubt. It's a big difference. They have to carry the day. They failed miserably. So all I'm asking you to do, folks, is do your duty. Do what you swore you would do. It's a decision that you gotta be able to look yourself in the mirror tomorrow, next week, a year from now, and say, I did the right thing. You know? You don't have to like Jeff. You don't have to like me. You don't have to like anybody in the courtroom. All you got to do is love the law and love the principles that we stand on. And you're going to get through this, and it's going to lead you to the conclusion that's inevitable, and that is not guilt. And Jeff and I want to thank you for sitting through this. It's truly appreciated. Thank you. Thank you, Judge.
State may make its closing argument.
As the attorney told you before, this is not a whodunit. There's not a ton of conflict here on what happened. This case is not a mystery. We know what happened. On December 15th of 2017, we know, you know, because you heard the facts. On that night, the defendant, this man right here, Jeffrey Woodburn, bit his fiancée, Emily Jacobs, on the hand. He bit her, and he caused bruising. We know that this adult, educated man bit his fiancée on her left hand because we have pictures of it. Emily testified and told you that's what happened. And even the defendant, for all the lies he told you today, he had to admit that. He had to admit, yeah, I bit her. So there's no mystery about that. The judge just gave you instructions on the law and the charges. The defense counsel talked to you about them a little bit. Talked about simple assault. The elements that the state has to prove to you beyond a reasonable doubt. And it's important that you do hold us to that burden. Beyond a reasonable doubt. The state has to prove, one, that the defendant caused Emily Jacobs bodily injury, and two, that he acted recklessly. Well, you have the pictures. These are 4 days after this happened. There's bruising there. The defendant admitted he bit her on the hand. He hurt her. She told you how that bite made her hand feel. That's bodily injury. You also have to find that the defendant acted recklessly, and the judge defined that for you. You've defined that the defendant was conscious of a risk that he would cause a particular result and acted anyway. Well, what that means here is that the defendant, an adult, educated man, knew that if he put his teeth on Emily's hand and bit down and clenched those teeth, there's a risk he's going to hurt her and cause bodily injury. He knew that. He knew that, and he bit her anyway. That's what that means. So those are the two elements. There's one additional element for domestic violence, simple assault. It's that the defendant and Emily were in an intimate relationship, that they were intimate partners. They were engaged. There's no dispute about that. So what are we doing here? We all agree he bit her. He put her hand in his mouth, and he bit down. We're here because the defendant wants you to believe that when he bit his fiancée, he was acting in self-defense. He wants you to believe that when he bit Emily, he was defending himself, keeping himself safe. Because supposedly, he couldn't leave the car that night. It wasn't safe for him to do that without his phone. That's what he told you. The only way for him to safely exit that car, to keep himself safe that night, was to bite her on the hand. Well, the judge instructed you on credibility. The defense counsel just talked to you about it. Spent some time talking about the Cabot Inn, drinks at a party. And it's true. Just because a witness says something on that stand doesn't mean that they're telling the truth. You, the jury, get to decide what's true. You get to decide who to believe. And so, when you examine what everyone has said here today, particularly the words that came out of his mouth, keep in mind you don't have to believe them just because he took an oath to tell the truth. When we met last week during jury selection, We asked you about ways that you can tell that someone is telling the truth. How do you know if someone is credible? We talked about things like evidence in support of what someone is saying. Talked about reasonableness and common sense. And those are all fantastic ways to tell if someone's actually telling the truth. We also talked about ways to tell if someone is not telling the truth, if someone is lying to you. You mentioned things like contradicting themselves and body language. Keep those in mind. So let's talk about the defendant's testimony today and his claim of self-defense. It's up to you to decide if you believe it. Just because I say it, or the defense attorney says it, you don't have to believe what we say. It's up to you. And when you do, when you look at all the evidence, and you use your common sense, you're going to have zero doubt that this defendant is guilty, that he lied to you repeatedly today, and that there was no self-defense. Not even close. The defendant told you today, from that stand, after he raised his right hand and swore to tell the truth, that he needed his phone to get out of the car. He said it was cold and dark. It was December. It was in Jefferson, New Hampshire. It was nighttime. He said that he couldn't leave that car that night without it. He needed it because he didn't think it was safe for him. But he also had to admit, didn't he, when I asked him some questions, that that's not what he said before. He testified under oath about the same incident at a previous hearing. And he admitted to you, because he had to, that he said something entirely different before. He said, I was going to leave that car with or without my phone. The first words out of his mouth when he was asked that question, were you going to get out of that car on that night in December on the side of the road without your phone? Absolutely. Yes. Those were the words he used. He had to admit that. Couldn't lie about that. And despite the fact that he swore oath to tell the truth at that previous hearing and said, I was going to get out of that car with or without my phone, he took the stand today and told you the exact opposite. What does that tell you? Think about contradictions. Think about what the judge said about whether or not you can consider a previous inconsistent statement. You can consider that as true. He was telling the truth before. No reason not to say that. He's got a lot of reasons to lie now. And that's what he did. He lied. He was asked again about it at that previous hearing. After he said he would get out of that car with or without his phone. Absolutely, yeah, that was my goal. He was asked again. You were asked before when you testified that you were getting out of that car with or without your phone. That was your testimony, correct? That was my testimony. That was the answer he gave. He had to admit that today. So how do you know if someone is a liar? How do you know if someone is lying to you? If they testify. They swear an oath to tell the truth and tell you two different things that both can't be true. Pretty simple. He lied to you. He has been caught in a lie. He's contradicted himself because he has to. He lied about other things today, too. When he took that stand and was being asked questions by his attorney, he was asked, what did you do after you got out of the car? He said, I started walking and I turned my phone off. Use your memories. You get to determine what you remember, what the testimony was. And when you do, I'll bet you remember him saying, yeah, I turned my phone off. And that's a problem for him, right? Because if he turned his phone off, that means he doesn't care about calling someone. He's not afraid. He wasn't in the North Pole trying to shoot a flare gun up to get some help. He was on the road where his fiancée lived, where he spent the night half the week. He knew at least 2 sets of neighbors there where he could have gone. He wasn't afraid for his safety. He wasn't feeling confined. He didn't need his phone. He was fine. He turned his phone off. Wasn't planning to call anybody. But then when I asked him to confirm that, you saw his body language. You saw his face. Got red. He was caught in a lie. And he lied again. He said, no, I was going to call Art. That's what I meant. I didn't say I turned my phone off. I called him and then I ended the call. That was a lie. He took that stand and he lied to you. How do you know if someone's not telling the truth? They get caught in a lie. The judge is gave you your instructions already about self-defense. So we've already established he bit her. He had to admit that. Caused an injury. We have photos about that. The judge didn't tell you in order to find the defendant guilty, he had to not only bite her and cause an injury, but break the skin, withdraw blood. No, that's not the law. He bit her, he hurt her, he caused bruising. That's what it is. The rest doesn't matter. And the judge gave you the instructions on self-defense. The first element of self-defense is that the defendant only has the right to use self-defense to bite Emily if he actually believed, actually in his own mind, believed that he was in imminent danger of Emily confining him or using force against him. Imminent danger. Ask yourselves, did the defendant, when he testified, tell you that? Honestly? Do you think he actually believed he was in any danger that night? He turned off his phone. He was going to get out of that car with or without his phone. There's no evidence that he actually believed any of that, what he told you. He told you that he thought, well, today he did, he needed his phone. He said, I had to have that phone so I could call somebody to pick me up if it wasn't safe for me. But we know that's not true. We know that's a lie. It's a bold-faced lie because he testified to the exact opposite previously. So we know that's not true. The judge also told you that not only must a person actually believe in their own mind that they are in danger, imminent danger, immediate, imminent danger of force being used against them or being confined. That belief actually has to be reasonable, right? It can't be some cockamamie belief that maybe someone actually believes, but it has to be reasonable. It has to be something that makes sense. Even if you assume the defendant actually believed he had to bite Emily to get that phone and be safe, is that reasonable? That's for you to decide. When you decide it, is it reasonable? No. Emily didn't lock the car doors. The defendant is not disputing that. He opened the door. She didn't lock the door to keep him in there. She didn't tell him, don't get out, stop, stay here. She didn't say anything to confine him. She didn't threaten him. She didn't do anything. She didn't raise a hand. She didn't hit him or punch him or slap him or threaten to do it. She didn't do any of those things. All she did was reach for his phone. Was it reasonable for the defendant to think that when Emily reached for his phone, he was in danger of being confined? That Emily was trying to confine him or somehow restrict his freedom? No. He told you today it was too dangerous out there for him to leave the car that night. He wants you to believe it was frozen tundra out there with no help for miles. And that without his phone, he might as well have been in the middle of the North Pole, completely stranded and alone with no help and in danger of his life. There was no danger to him that night. It was December. Cold, yes. Dark, sure. But he wasn't in the middle of nowhere. He wasn't on the top of Mount Washington in the middle of a storm. He was on Highfield Lane. There's a map here. You can take it with you in the deliberation room. Emily's house was just up the road. The house where he lived 2 to 3 days a week, where he spent the night, where he had things. He could have gone to at least 2 other houses on that road, 37 and 99. Would it be embarrassing, maybe, to have to knock on the door? but he could have done it. He wasn't in any danger. He wasn't far from help. The defendant was not in any actual danger that night. We know that because he said so under oath. When he testified at that previous hearing, he was going to get out of that car even if he didn't have his phone. He wasn't scared. So even this false belief he's trying to sell you today, it's not a reasonable one. Even if he did have that belief, which we know he was lying about, it's not reasonable. Lastly, even if you get past those hurdles, the judge told you a defendant can only use a reasonable amount of force. In order for a defendant to have the right to use force in his own defense, he must reasonably believe that the amount of force is not excessive. The defendant took his mouth, put it on Emily's left hand, and he bit down hard, causing bruising. Her hand hurt for days. That wasn't reasonable. It wasn't justified. It wasn't called for. It was criminal. You've seen the defendant. Look at him. He's 6'2". You saw his hands. He outweighs Emily. These are all important facts in the context of what happened. Do you really think that the only way for him to get a phone out of Emily's hands, even if there was a tug of war, was to bite her? He could have ripped that phone out of her hands easily. There's no doubt about that. Instead of doing that, something else, he bit her. There's no mystery about what happened that night. The defendant, a large, adult, immature man, had been drinking. He wasn't getting what he wanted. Emily, his fiancée, had dared to question him, to question the plan. But she had to get up early and drive him. Is that childish? Maybe. But is it wrong? Can a fiancée question a plan that she doesn't like? Does it matter who starts an argument? The judge didn't tell you that. He didn't tell you that Emily can't be the victim of assault because she started an argument that ended up with the defendant biting her. That's not the law. What the defendant did was not self-defense. He was angry. He was drinking. He was immature. His actions were not reasonable. The defendant's story that he thought he had to get his phone by biting Emily is laughable. It's ludicrous. It's one of many lies that he told you today. Many, many lies. I asked him at the end of his testimony, you remember testifying before that you were ashamed of biting her? He lied about that too. He said today that he thought what he did was the right thing to do. He thought it was a logical, reasonable thing. Even though he testified at a previous hearing under oath that he was ashamed of what he'd done, and that he said, what I did was not a proper act. He knew then, and he knows now, what he did was wrong. It was not self-defense. It was assault. So when you go back to deliberate, you'll have the photos, you'll have the map, and you'll have your own memories about what Emily said and what the defendant told you. Examine them. Use your common sense. And there's only one verdict you can reach. That's guilty. Reject the ridiculous lies that he told you from that stand. Reject them and find the defendant guilty. Thank you.
Members of the jury, the principles of law that I've given you are intended to guide you in reaching a fair result in this case, which is important to both parties in the courtroom and to the court. You are to exercise your judgment and your common sense, as I said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. When you've considered and weighed all the evidence, you must make one of the following findings with respect to each charge that is before you. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the offense charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. Your verdict must be unanimous. All 12 jurors must agree on your verdict. When you've arrived at your verdict, let the bailiff know, and the court will reconvene in the courtroom, and the foreperson will render that verdict orally in response to questions that the clerk of court will ask you. The foreperson who you will select as your first order of business should see to it that the jury takes up the issues that are before you. He or she should see to it that each juror has a full, fair, and an adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. I suggest that that deliberation is a 3-stage process. Each juror must first think for himself or herself about the evidence and about the law. Each juror should listen carefully to what your fellow jurors have to say about the evidence and about the law. And then each juror should speak up and let your fellow jurors know what your opinions and views and positions are on the evidence and on the law. If any questions should arise during your deliberations, the foreperson should write the question out, sign it if you're ever to do so, write the time that you're writing the question on the question, hand the question to the bailiff, and the question will be brought to me, and I will respond to your questions accordingly. I do want to thank you all for your attention now, and I'll select the alternates, the jurors. As you've observed, there are 14 of you, and 12 of you will serve. I have a cup here with 14 die in it with your numbers on it, and I will, if I can ever get them out here, randomly select 2 numbers, and jurors number 6 and 10 are the 2 alternates. I do want to thank the alternates for your service, and in a moment when we recess, I'd like to see the alternates briefly at the bench, so when the other jurors return to the deliberation room, the alternates can just step out of line and come up to the bench. Again, before you start your deliberations, you must elect a foreperson. As soon as you do so, please indicate your choice in writing and give that note to the bailiff. The jury may now leave the courtroom, and I will see copies of the instructions and the exhibits are brought to you. Jurors may be excused.
Where's number 10? Yeah. Here, yeah, you come this way, yeah. Is your number still around there if you'd like?
All right, come on up. Wait till we get our second alternate back here.
Coming out, Ralph. Yeah, it's coming in.
All right, come on over here, sir. So the fact that you were selected as alternates doesn't diminish the value or the importance of your service as jurors. Until the jury returns with a verdict, you'll stay here in the courthouse. Again, in case one or both of you may need to serve as an alternate, I'd still ask you not discuss the case amongst yourself with anybody else, and avoid being exposed to any information having to do with the case or the people in it from any source whatsoever. So thank you for your service. The bailiff will take you down to the other room, and if you left things in there, he'll help you get them.
All right, thank you, sir.
And court is adjourned.
All right.